authorities, even having lapsed the scheme, they used to issue the endorsement saying that not accepting the, not issuing the layout plan on the ground that this land is notified. So, idu Supreme Court do.
Malad?
You please look at that judgment. Court. Vijay Lakshmi.
Vijay Lakshmi, Malad.
Where they have said.
Bangalore. Vijay Lakshmi is principal bench, Malad.
Allah, Supreme Court. I am talking of Supreme Court judgment arising from Karnataka only. Adralli they have said the authority to consider the sanction of plan has to decide on the basis of the existing circumstances. You cannot anticipate. Illa inge proposal ondide munde hinga agutte adu angalla ಮಾಡಿ ಮಾಡಕ ಆಗೋದಿಲ್ಲ. ಅಲ್ಲ, ಇದು ಹಂಗೇನಲ್ಲ. No, that is in your favor. Yes, sir. That judgment will be in your favor, sir. Yes, please. You please get it. Yes. Illi the scheme itself has lapsed. Yes. Even if there is a proposal to redo it, yes, it will come into operation only at the point of time when they issue such notification. Yes. Therefore, your application cannot be rejected on that ground. Vijay Lakshmi jana ide. Yes. So, AG, I don't think you have a case. And directions are issued to the Urban Development Authority and
Malad, if the case, there is no case, we will admit it, Malad. We don't want to be mislead this court.
Directions are issued to the Urban Development Authority and the state has come up in appeal.
Please, Malad. And I will also go through.
Totally unacceptable.
I understood, Malad. I will also go through this Vijay Lakshmi case, Malad. If it is in favor of even the respondent also, we don't mind. But we would like to know what is the fact, whether it is going to be applicable in this. Since my lordship said that there is some meaning, and we will go through, Malad. Monday, Malad, my prayer to be kindly have it on Monday.
The request of the learned Additional Advocate General release this matter on 2nd of December.
Much obliged, Malad. Malad, the delay may be condoned, Malad. 83 days days, Malad.
TV Vijay Lakshmi, our citation ಕೊಟ್ಬಿಡಿ. ಅವರಿಬ್ಬರಿಗೂ citation ಕೊಟ್ಬಿಡಿ.
Yeah, please. Malad, delay may be condoned, Malad. 83 days delay.
We will see.
2007 SC.
Grateful, Malad.
ನೀವು ಬರ್ಕೊಂಡ್ರಿ
2006 volume 8 SCC 131. 2006 volume 8 SCC 502.
50.
Yeah, 2007.
Party yesterday.
I collected. Vijay Lakshmi and other sources town planning number and another.
Delay may be condoned, Malad.
No, not today. You will see. Yes.
Please, Malad.
Serial number 9, Government Advocate.
Third respondent is not served, my lord. Third respondent, my lord, the KOT is filed by the my lord advocate, my lord. That is returned, my lord. Signature is not there.
Huh?
In the wakalat.
Respond number 3.
Okay.
ಯಾವುದು?
In
Serial number 9.
9. But in wakalat R3 signature not.
Wakalat respond number 3. ಏನು ಕರಡಿ ಅವರೇ ನೀವ್ ಹಾಕಿರೋದಾ?
ಇಲ್ಲ, ಅದು ನಾನು ಹಾಕಿಲ್ಲ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3. ವಕಾಲತ್ ಫೈಲ್ಡ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3.
ಹೌದು, ಇವರೇ ಹಾಕಿದ್ದು. KVET filed in respect of 1 to 4. However, in wakalat R3 signature not forthcoming.
ಅಷ್ಟೇ ತಾನೆ. Signature is not forthcoming.
ವಕಾಲತ್ ಅಲ್ಲಿ ಇಲ್ಲ.
KVET.
Let him take notice, man.
One, 2, 3 and 4. You are not appearing for whom?
3 ಅಂತ ತಿಳಿದೈತೆ. But if my lords direct.
4 ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. You are appearing for all the 4?
No, 1, 2, and 4.
1, 2, and 4. Not respond number 3.
Yes,
You are not appearing for respond number 3.
please, my lord.
Then I will take steps, my lord.
ಅಲ್ಲಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಳಿದದ ಉತ್ತರ ಕೊಟ್ಟಿನಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಟೇಕ್
ಅಲ್ಲಲ್ಲ ಹಂಗಲ್ಲ.
ನೋಟಿಸ್.
ನೀವು ಕೇವೇಟ್ ಹಾಕಿದ್ರಿ.
ಹೌದು ಸಾಹೇಬ್ರೆ.
Did you intend to appear for all the 4 respondents or only some of them?
ನನಗೆ ಅದು ನೆನಪಿಲ್ಲ. If my lords to assist the court, I will take notice for R3 also.
ಬಟ್ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ಅವ್ರ ಕೇವೇಟ್ ಅಲ್ಲಿ ಅವ್ರ ಪ್ರಕಾರ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಯಾರು ನೋಡಿ?
Respond number 3 is the
ರೇವಣ ಸಿದ್ಧ ಅದಾರ ನೋಡ್ತೀವಿ.
Revana Siddha.
You have filed ವಕಾಲತ್ ಫಾರ್ ಭಾಗವ್ವ, ಮಹಾದೇವಿ
ಅಂಡ್ ಶ್ರೀಶೈಲ.
ಇಲ್ಲ 4 ಜನದ ಹೆಸರು ಇದೆ ಇಲ್ಲಿ.
ಹಾ,
ಭಾಗವ್ವ, ಮಹಾದೇವಿ ಅಂಡ್ ಶ್ರೀಶೈಲ.
Revana.
ನಿಮ್ಮ ಕೇವಿಯಟ್ ಹಾಕೋವಾಗ್ಲೇ
ಅದೇ ಬೈ
ಅದನ್ನ you have struck down
ರೇವಣ ಸಿದ್ಧ.
Revan Siddha. You have struck it down and therefore wakalat is not there.
Please.
So you are not appearing for Revan Siddha.
Please.
Since learned counsel Shri Baswaraj Karaddi is appearing for response number 1, 2, and 4, the appellant is required to take fresh steps for service of notice on response number 3. Full stop. A week's time is granted to do the need.
Please.
Number 10, Vilappa Yerur.
In this matter, my lord, your lordship
for
is
the-
requested me to.
Last time
inform
I have
the
furnished the
official-
telephone number of the respondent number 4
sir.
also.
Sure. Here. Your lordship is directed me to communicate to the respond number 4, my lord. Respond number 4, my lord, he is not appeared. And your lordship is directed me to call through mobile to her and request her to appear through advocate. But I called her, my lord. She refused to engage the advocate. I received the message also.
You are required to take steps then.
Already, my lord may peruse the order said it has already been dispensed to the.
He is making a submission. He spoke to that lady. She said, no, I don't want.
Kindly record it as refused and may be taken as.
Refused agala. Refused agala because notice was not issued till now.
I have served by hand summons also.
Sir, if served, then that time itself it should have been taken.
Hand summons I have served. I filed the acknowledgement also.
Howda?
Kindly see my memo, 9th September. 9th September. In obedience of the order of this honorable court, I have taken hand summons, served, and GPS also I have filed.
Received personally.
It is served and filed also.
Sunanda.
Yes, my lord. Yes. And she did not appear before the learned single judge. And this honorable court had held it.
He is also written her telephone mobile number.
Yes, yes, yes.
Huh?
She has signed a written mobile number also. She has received the copy from me by hand summons.
On the previous occasion, we had requested the learned government advocate to secure instructions from respond number 4 through the other official respondents. For ensuring appearance on behalf of respondent number 4. Full stop. Learned government advocate submits that he has contacted the 4th respondent over telephone and she has refused to permit the government advocate to represent respondent number 4 before this court. Full stop. Next para. Learned counsel for the appellant has also drawn the attention of this court to the hand summons filed along with memo on 12th of September 2024 and submits that the fourth respondent has received the hand summons by affixing a
22nd August.
signature on 22/8/2024, and she has also written her cell phone number. Full stop. Next para. Having regard to the fact that the hand summons is served on respondent number 4, comma, we hold that the notice is sufficiently served on respondent number. Yes.
I'm called on Monday, my lord, for preliminary hearing, disposal.
Ready, my lord. It is a selection of the fourth respondent, my lord, challenged.
If you are ready today, we'll finish
Yes,
it
my
off.
lord, I am ready.
Monday. Today I'm not ready. Today I'm not ready.
List this matter for preliminary hearing on 2nd of December.
CL number 11, Deepak V. Barat.
This
In this
contempt
matter, my
petition
lord.
has been filed. for
Last occasion, your
disobedience.
lordship is, my lord, directed me to get the stay order, my lord, before the affairs court.
Hmm.
But we requested the, my lord, advocate on
We
record, my
are
lord.
required to proceed.
Yes, that's why I'm kind of, I filed the memo, my lord, yesterday, that is 26, my lord.
Yenanta?
I requested the advocate on record, my lord.
Huh.
He informed through his letter, my lord, on 25/11/2024.
Hmm?
Memo, my lord. Along with memo, my lord, I produced that letter.
Letter.
Yes, letter of the, my lord, on record advocate of the affects court.
Letter.
ಹೌದು.
ಎಲ್ಲಿದೆ? ಬಂದಿಲ್ಲ.
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿರಿ ಸರ್.
ನಿನ್ನೆ.
That has not been put up.
ಹೌದು.
On record advocate letter has been given.
Huh?
Advocate on record letter has been given. He
Ah.
is seeking 1 week's time for the. Since there is no interim order as such, my lord, in the SLP.
ಅಲ್ಲ, that's all, ಅದು ಗೊತ್ತಾಯ್ತು. But
That's
we
why,
have
my lord.
indicated.
Yes, but for that is the reason, my lord, we requested, my lord,
Hmm.
to the advocate to move the matter before the CJ for getting this matter, since the contempt is filed before this court. He, my lord, requested, my lord, then he returned a letter to us, my lord. Some time is required, getting that matter.
Only, my lord, notional retirement benefits has to be given in this arrears. Since, my lord, he had been retired by attending superannuation during the pendency of the application before the gate itself. By considering this, all the aspects, my lords have ordered for arrears of retirement benefits, my lords. An endorsement was issued, my lord, on merits, my lords have considered that he has attended the PUC during the course while he was employment. My lord. In fact, he had finished his course, my lord, before the appointment itself. On merits, my lords have considered this.
ಏನ್ರಿ, we have taken everything into consideration.
That's true, my lord. But our contention, my lord, para 8 of your lordship's order, my lord. That two more subjects, my lord, for that is the reason, my lord, endorsement was issued. Would submit that in the impugned endorsement dated 13/10/2019, it is rightly stated that the rules require.
Paragraph?
Para 8 of the lordship's order. Para 8, my lord.
Per
Per contra, yes, ma'am. Yes, ma'am. Per contra, the learned so and so would submit that in the impugned endorsement dated 13/10/2009, it is rightly stated that the rules require that the petitioner should not only have a Hindi Rashtriya Bhavana, Rashtriya Bhasha Pravina certificate, but also pre-university certificate. So this was not, my lord, satisfied by the, my lord, candidate. For there is a reason, my lord, endorsement dated 13/10/2009 was issued. Your lordship is, my lord, considered that one, my lord, para 10. Para 10, your lordship's order, my lord, that is considered, but your lordship is also taken that, my lord, she passed the examination. But, my lord, without permission from the department, my lord,
The
she
rules were brought in the year 2002.
2002.
2002, my lord.
Appointment was made in the year
77.
1977.
That's why, my lord, that's why, my lord, the endorsement, my lord, if I having, my lord,
Has
endorsement.
been
my lord, I-
considered by my lords, my lord, by at length.
ಎಲ್ಲ ಮಾಡಿದ್ವಿ. What is this?
That's why, my lord, place, my lord, short time, my lord, I'll get the, my lord, because it's
No, no.
the, not only, my lord, this person is, my lord, because our submission, my lord, if it is, my lord, permitted these types of, my lord, the candidates, my lord, then, my lord, other candidates has also come up.
ಏನಾಗಿದೆ ಹೇಳಿ? Have you understood what has happened?
Yes, my lord, that's true, my lord.
ಹೇಳಿ, what has happened?
But endorsement, endorsement. But endorsement, my lord, that is not before lordship, my lord, that is. 13/10/2009, my lord. That ಇದೆ ನಿಮ್ಮ ಹತ್ರ? What is, sir? But we stated detailedly, my lord, that one. I read, my lord.
ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹಾ?
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನೋಡಿ.
ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
Yes,
ಅಪೀಲ್ ಮೆಮೋಲ್ ಇದೆಯಾ?
Yes, ma'am.
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
Page 79, 821.
ಅಲ್ಲಿ ಎದ್ರಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್
In this note.
ಇದ್ರಲ್ಲಿಲ್ಲ.
ಇದರಲ್ಲಿ
ಹಾ.
13/10/2009, my lord. ವಿಷಯ, my lord, ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ತರಬೇತಿ ಹೊಂದಿದ ಪದವೀಧರ ಶಿಕ್ಷಕರ ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರ ಗ್ರೇಡ್ 2 ಹುದ್ದೆಗೆ ಜ್ಯೇಷ್ಠತೆ ಮತ್ತು ಅರ್ಹತೆ ಆಧಾರದ ಮೇಲೆ ಬಡ್ತಿ ನೀಡುವ ಬಗ್ಗೆ ಬೀದರ್ ಜಿಲ್ಲೆಯ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ತರಬೇತಿ ಹೊಂದಿದ ಪದವೀಧರರು ಶಿಕ್ಷಕರನ್ನು ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ಬಡ್ತಿ ನೀಡಲು ತಾತ್ಕಾಲಿಕ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಎಲ್ಲಾ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಕರುಗಳ ಕಚೇರಿಯಲ್ಲಿ ಪ್ರಕಟಿಸಿ ಬಾಧಿತ ಶಿಕ್ಷಕರಿಂದ ಅಪೇಕ್ಷಣೆಗಳನ್ನು ಪಡೆಯಲಾಗಿದೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 5ರಂತೆ ಸಲ್ಲಿಸಲಾದ ನಿಮ್ಮ ಆಕ್ಷೇಪಣೆಯನ್ನು ಉಲ್ಲೇಖ 2, 3, 4 ಬೆಳಕಿನಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ನೀವು ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕ ಹಿಂದಿ ಹುದ್ದೆಗೆ ಅರ್ಹತೆ ಹೊಂದಿರುವುದಾಗಿ ನಮೂದಿಸುತ್ತಾ ಅದನ್ನು ಪರಿಗಣಿಸಿ ಬಡ್ತಿ ನೀಡಲು ಕೋರಿರುವಿರಿ. ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳಲ್ಲಿ ಹಾಗೂ ಉಲ್ಲೇಖ 3ರ ಸರ್ಕಾರದ ತಿದ್ದುಪಡಿ ಆದೇಶದಲ್ಲಿ ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕ ಹಿಂದಿ ಹುದ್ದೆಗೆ ಶೈಕ್ಷಣಿಕ ಅರ್ಹತೆ ನಿಗದಿಪಡಿಸಲಾಗಿದ್ದು, ಈ ಶೈಕ್ಷಣಿಕ ಅರ್ಹತೆ ನೇರ ನೇಮಕಾತಿ ಹಾಗೂ ಬಡ್ತಿ ಎರಡಕ್ಕೂ ಅನ್ವಯವಾಗುತ್ತದೆ. ನೀವು ದಿನಾಂಕ 1/8/2024 ರಾಜಸ್ಥಾನಿ ಹಿಂದಿ ವಿಶ್ವವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿ ಜಿಲ್ಲೆ ಧಾರವಾಡ ಸಹ ಶಿಕ್ಷಕರಾಗಿ ನೇಮಕೊಂಡಿರುವುದನ್ನು ಸಹಾಯಕ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಹುಬ್ಬಳ್ಳಿ ವಲಯ ಇವರಿಂದ ತಮ್ಮ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಗಳಂತೆ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಲಾಗಿದೆ. ತದನಂತರ ನೀವು ದಿನಾಂಕ 24/8/2077 ಸಹ ಶಿಕ್ಷಕರಾಗಿ ಸರ್ಕಾರಿ ಮಾದರಿ ಕನ್ನಡ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಶಿಗ್ಗಾಂವದಲ್ಲಿ ನೇರ ನೇಮಕಾತಿ ಮೂಲಕ ಪ್ರಾಥಮಿಕ ಶಾಲಾ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಹೊಂದಿರುತ್ತೀರಿ. ನೀವು ಮಾರ್ಚ್ 1967ರಲ್ಲಿ SSLC ಪಾಸ್ ಆಗಿದ್ದು, 1975-76ರಲ್ಲಿ PUC ಪ್ರಥಮ, 76-77ರಲ್ಲಿ PUC ದ್ವಿತೀಯ ಪರೀಕ್ಷಾ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಮೂಲಕ ನೆಹರು ಆರ್ಟ್ಸ್ ಕಾಲೇಜ್ ಹುಬ್ಬಳ್ಳಿಯಿಂದ ರೆಗ್ಯುಲರ್ ಅಭ್ಯರ್ಥಿಯಾಗಿ ಅಧ್ಯಯನ ಮಾಡಿ ಪಾಸ್ ಆಗಿರುತ್ತೀರಿ. ಮುಂದುವರೆದು ನೀವು ಕರ್ನಾಟಕ ಮಹಿಳಾ ಹಿಂದಿ ಸೇವಾ ಸಮಿತಿ ಬೆಂಗಳೂರವರಿಂದ ಹಿಂದಿ ಭಾಷಾ ಪ್ರವೀಣ 1972ರಲ್ಲಿ ಉತ್ತೀರ್ಣಗೊಂಡು 72-73 ಸಾಲಿನ ಹಿಂದಿ ಶಿಕ್ಷಕ ಪರೀಕ್ಷೆ ಮೂಲಕ ರೆಗ್ಯುಲರ್ ಅಭ್ಯರ್ಥಿಯಾಗಿ ಪಾಸ್ ಆಗಿರುತ್ತೀರಿ. ಸದರಿ ತರಬೇತಿಯಲ್ಲಿ ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಕೇವಲ ಹಿಂದಿ ಭಾಷೆ ಮಾತ್ರ ಬೋಧನಾ ವಿಧಾನವನ್ನಾಗಿ ಅಧ್ಯಯನ ಮಾಡಿದ್ದು, ವೃಂದ ಹಾಗೂ ನೇಮಕಾತಿ ನಿಯಮಗಳಂತೆ ಹಿಂದಿ ಭಾಷೆಯೊಡನೆ ಇನ್ನೊಂದು ಭಾಷೆ ಬೋಧನಾ ವಿಧಾನವಾಗಿ ಅಧ್ಯಯನ ಮಾಡುವ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. ನೀವು ಸರ್ಕಾರದಿಂದ ಅನುದಾನ ಪಡೆಯುತ್ತಿರುವ ಖಾಸಗಿ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಅನುಮೋದಿತ ಸೇವೆಯಲ್ಲಿದ್ದು, ಅದೇ ಸಮಯದಲ್ಲಿ PUC ರೆಗ್ಯುಲರ್ ಅಭ್ಯರ್ಥಿಯಾಗಿ ಪಾಸು ಮಾಡಿದ್ದು, ಉಲ್ಲೇಖ 4ರ ಆದೇಶದಂತೆ ನೇಮಭಾರವಾಗಿದ್ದು, ಇದೇ ಆದೇಶದ ಬೆಳಕಿನಲ್ಲಿ ನಿಮ್ಮ
Consider this one.
this one regular student, my lord, that is, my lord, without getting permission from the department to see attended the regularly.
We have answered that.
That is,
Yeah.
my lord, we
He had
even
taken up the exam
In March,
before.
August, he has been appointed
The results were announced later.
later.
Please understand.
when she appeared, my lord, that is also, my lord.
What is this?
Appointment is of August, my lord, and he has appeared in examination in March. One subject he had failed, my lord, and mass card was issued in December. Issuance of mass card in a year December, my lord, subsequently.
That is, my lord, when, my lord, she appeared only, this is the mass card, my lord, this is also, we are obtained the mass card also.
Adhere,
Ella consider
marks card was issued later.
later in December.
For the
Here.
examination.
He had appeared for the first examination, regular examination, when?
Civil.
In March.
If he failed one subject, my lord, entire, my lord, CV is
Been
failed.
considered.
That is the, my lord, instruction, my lord.
Huh?
I request your lordship, my lord, permit him to additional
Yeah.
commissioner, my lord.
You are talking as if we don't know anything about examinations.
That's why, my lord,
Huh? We have not passed examinations.
we pass. my
Is
lord.
there no provision for supplementary examination?
There.
Then he has written the supplementary examination, and that was also written even before he could be appointed. Everything we have taken into consideration, but you are not satisfied. This is the attitude of our officers. Anyway, you have taken up before the Supreme Court. You want to test it, you can test it. But we are not going to wait for all that.
Lordship, finally, lordship, grant 2 weeks time, my lord, if within that
No
period, my
2
lord,
weeks
we are
time,
not,
sir.
because, my lord, government, when government is decided, my lord, we are helpless, my lord.
That order was passed on 30th of October
Yes.
2023.
Yes. Yes, my lord, that is
Then?
true.
What were you doing all these days?
Because getting the,
ಅದೇ ಕಂಟೆಂಪ್ಟ್ ಬಂದಾಗ ಆಮೇಲೆ ಹಾಕೋದು ಅಪೀಲ್. We will proceed. We will proceed to hear before framing charges.
grant, my lord, at least week's time, my lord. Again, we'll request to the, my lord, affect court, on record advocate, my lord. If not, my lord, then I'm leaving to lordship.
In our previous order, we had made it clear. That since the respondents have not been able to secure any order of stay at the hands of the Honorable Supreme Court. We proceeded to list this matter today, either for compliance or enable the court to proceed with the contempt petition in accordance with law. Full stop. However, learned government advocate submits that he has filed a memo along with the communication made by the advocate on record before the Honorable Supreme Court, stating that there are some defects in the SLP and the same will be cured. And thereafter, the matter will be listed for admission. Full stop. Next paragraph. We find that the orders passed by this court allowing the writ petition was on 30th of October 2023. And more than a year has elapsed. Full stop. It is only after the contempt petition is filed, the respondents have woken up and decided to file an SLP. Full stop. We are therefore constrained to proceed to consider the contempt petition. Full stop. Next paragraph.
Respondent
Release
2 and
matter.
3 is present before Lordship.
Release this matter on 5th of December. That is the maximum that we can do. 5th of December to hear the respondents before framing of charges. Yes,
What your Lordship is saying,
the respondents is required to be present before this court on the next date of hearing.
today, my lord, respondent 2 and 3 is present before Lordship, my lord. That can
Agree.
be noted. Lordship, my lord,
All
can
right.
be noted, my lord.
Huh?
Yeah. Respondent
No,
2 and 3
we
is
want,
present.
we want them next time. Let them come.
Please.
Yes.
Appeal number 12, Ravi B. Patil.
Serial number 12 to my lord, 16, my lord. State appeals, my lord, dismissed by your Lordship, my lord. This is pertaining to the Waqf property and Inam lands, my lord. That one, my lord, conversion, my lord, application was rejected after the prescribed, my lord, time. Our appeal, my lord, recently your Lordship is dismissed. My lord.
Huh?
Our appeals, my lord, filed by the
Huh.
state, my lord, dismissed, my lord,
Huh.
your Lordship. That copy, my
Detailed
lord,
order was
your Lordship,
passed.
some more time is required. 1 week time is required, my lord.
Huh?
No, no, no.
1 week time is required, my lord, for us, my lord.
For what?
Because, my lord, that copy is, my lord, not available still.
Huh?
Copy which is writ appeal, my lord, dismissed by your Lordship. my lord.
Hmm.
That copy is, my lord, not yet.
My lord, yesterday we were called, my lord, by the office of Deputy Commissioner for attending the inquiry.
Inquiry.
Oh, 26.
On this very same issue.
4:30. Went to one of the office of Deputy Commissioner. Deputy Commissioner was on leave. And next, my lord, they have,
What is-
Copy.
though, my lord, though this court has passed a detailed order in the contempt proceedings on 11/11.
Hmm.
Specifically granting 1 week time to assess the fee payable and 1 week for issuance of a certificate. Now they want to hold inquiry and they have issued notice again to the Waqf authority also.
Twenty-one, 11/2024.
That is being served on us on 25th evening. And we were directed to be present on 26th. We have went, my lord, to the office and, my lord, also gave a detailed representation enclosing the copy of the order passed in contempt as well as the writ appeal, my lord, which has been disposed by this court. And we have said, my lord.
Yesterday.
ನಿನ್ನೆ
26th.
ಅವ್ರು ಇರ್ಲಿಲ್ಲ. Deputy Commissioner was not
yesterday.
there. ಹೌದು. My lord, once, my lord, this court has passed a detailed order on 11/11. Again, my lord, the question of holding inquiry by the Deputy Commissioner, my lord, This amounts, further amounts to contempt.
But fortunately, he has not mentioned our order dated 11/11/2024.
ಅದು ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾರೆ sir.
That is the order of the learned single judge. That is the order passed by the learned single judge. ಅವ್ರೇನಾದ್ರೂ ನಮ್ಗೆ ಇದ್ರ ರೆಫರ್ ಮಾಡಿದ್ರೆ
ಮಾಡೋದು ಇಮೇಲ್ ಆದೇಶ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಇಮೇಲ್ ಸಂದೇಶ 12
They have referred to it, my
Referred
lord. In fact, they have. at
And
least
we have
issued
also
notice to
enclosed the
it.
amount
copy
to
of
contempt.
Lordship,
Sure amount to contempt.
Lordship directed the deputy commissioner to be present tomorrow itself, my lord. Even morning I spoke to her, my lord.
ಬರ್ಕೊಳ್ಳಿ.
Tomorrow only let him present. Explain the.
Despite our orders dated 11/11/2024, directing the respondent deputy commissioner, Bidar, to collect the necessary fee, if not already paid, and proceed to pass orders while issuing certificate of conversion in terms of the deeming provision contained in section 95 of the Karnataka Land Revenue Act, and the same being communicated by email by the learned government advocate on 12/11/2024 to the deputy commissioner, the deputy commissioner has issued a notice on 21/11/2024 calling on the complainants to appear before the deputy commissioner on 26/11/2024 along with documents, for inquiry. Full stop. This, according to us, borders on contempt. Full stop. Next para. Nevertheless, to give an opportunity to the respondent deputy commissioner, list this matter, relist this matter on 2nd of December 2024. Full stop. The respondent deputy commissioner is directed to be present before this court on the next date of hearing. Yes.
I file with memo, my lord.
Huh?
ಇವತ್ ಬೆಳಿಗ್ಗೆ
Yeah,
ತಂದ್ಕೊಡಿ. Along with memo, I'll.
Yes, yes.
Copy of the order may be given.
The copy of this order shall be served on the learned government advocate.
So ಅಷ್ಟೇ ಅಂತೀರಿ? ಎರಡು memo ಬರ್ತೀನಿ.
up to 16 same, up to 16.
Up to 6.
To 16,
Same,
please,
12, 13, 14, 15, 16.
16.
Yes.
Seal number 17, Arun Kumar Amargundappa.
In this matter, my lord, this is, my lord, rowdy sheeters, my lord. There is a direction to the superintendent of police to pass the order, my lord. We pass the order, my lord, we,
Rejecting the application, huh?
yes, my lord.
Huh?
No, not rejecting, my lord. Close that rowdy sheet.
Close ಮಾಡಿದೆ.
Yes, my lord.
ಆಯ್ತರಮ್ಮ.
Page number 3 is the order of the superintendent of police.
Learned government advocate has filed a memo. Along with copy of endorsement dated 26/11/2024
And order of the SP.
and copy of order dated 24/11/2024 passed by
Superintendent,
ಯಾರು?
superintendent of police.
The superintendent of police, Kalaburagi. Full stop. Learned government advocate submits that the application given by the complainant for removing his name from the rowdy sheeters list has been considered. And in terms of the orders passed by the superintendent of police, the complainant's name has been removed from the rowdy sheeters list. Full stop. Next para. learned counsel for the complainant submits that the complainant is satisfied with the action taken by the respondents in terms of the directions issued by the learned single judge. Full stop. Next, accordingly, the contempt petition is closed.
Seal number 18, Erna Basappa M. Patil.
Hearing for the appellant, my lord, this is the insurance appeal, my lord, submit, office objection raised on the wakalatnama is signed by the DM, sir, my lords. And affidavit is sworn by the administrative officer because of his absence. There was this authorization was also given to him to swear.
Appellant signature does not tally with wakalat.
DM, the divisional manager has earlier filed to wakalatnama, my lords. Thereafter, swearing of affidavit, my lords, at the time of filing appeal, my lords, he was on leave, my lord. Authorization was given to the administrative officer, my lords. He has sworn the affidavit, my lords. That is the council submission, my lords.
Difference between
Persons,
the
yes, ma'am.
wakalat
Wakalat and
signature found in the IA.
IAS, my lords.
Huh?
Yes, ma'am. Administrative officer was been given authorization to
Office objection at serial number 5 is overruled. Yes.
This is a liability appeal, my lords, as well as quantum appeal, my lord, challenging both, my lords. Liability is that, my lord, there is a delay of 10 days in lodging complaint. And also, my lords, one more P2 is the ML's complaint, my lord. P4 is the complaint, my lords. Both are different version has been stated by the injured, my lords. And earlier he says that in the he fell down from the skid of the motorcycle. He was riding the bike, my lord, before the MLC before the, and in complaint he has stated that he was pillion rider, my lords. For that
Is one submission. Lords. They examined respondent number 2, PW2. Respondent number 2 is a doctor who has examined. He has given evidence. He is not from skid, not from, he is a pillion rider. Liability, pair number 21 are either. And for the
We'll have to consider, isn't it?
50% amount, the case of death, release money.
Learned counsel Sri Sanjeev Patil has entered appearance for
Respondent number 1 to 4.
response number
1 to 4.
1 to 4.
1 to 4. 1 to 4.
1 to
Claimants,
yes,
Claimants.
respond number 5 is
Owner.
of the vehicle.
yes, ma'am. Yes.
Issue notice to respond number 5. Next para. Although there is a delay of 27 days in filing the appeal, learned counsel for the appellant insurance company submits that the claimants have preferred execution case. Hakidara innu illa.
I don't know, my lord. That I don't know, my lord.
Submits that if the that the appellants have filed this appeal contending that liability cannot be fastened on the insurance company, and therefore the impugned judgment and award is required to be stayed, if not, the claimants will proceed to seek execution of the judgment and award. Full stop. Next para. Consequently, delay is condoned. IA 1 of 2024 is accordingly disposed of. There shall be an interim order of stay of the impugned judgment and award in MBC 874 of 2021 on the file of the Principal Senior Civil Judge and MACT, Kalaburagi, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
Permitted to withdraw Lordship 50% amount.
That we will consider. You file an application.
Lordship,
You file an application for that, we will consider. Yes,
Hearing on a CL number
because they are questioning liability,
no,
we'll have to say something on that. Yes,
hearing on a
Being
CL number
propellant.
19 Niva M Chimkod.
Lordship, in this matter, I seek adjournment.
Huh?
I seek adjournment, Lordship, in this matter.
And for respondent 1 to 3.
at the request of learned counsel for the learned counsel, Srimati Niva M Chimkod, release this matter on 3rd
Third,
of December. Yes,
CL number 20 Government Advocate.
These all the matters, my lord, your lordship is last occasion posted today, my lord. The behind 120 days, my lord, earlier bench, my lord, condoned the delay. And other side filed the application for recalling, my lord. In this matter, my lord, even the Harvard bench also, my lord, that is dismissed, my lord. Against that, my lord, SLP is prepared before the apex court, my lord, that is pending. And my lord, Additional Advocate General, my lord, requested me to take this matter by on 2nd, my lord. You see, these all the matters, my lord, which is the Harvard bench, my lord, dismissed the application. Against that, SLP is filed. These matters, may be lordship have it on 2nd, my lord.
Last occasion, my lord,
It was agreed on the last occasion that they will commence the arguments.
but Justice Nagaprasanna was part of the bench which passed that order.
Natarajan, K. Natarajan. Harvard bench order, my lord.
ಅದಲ್ಲ
ಯಾವ್ದು?
ಇಲ್ಲಿ ಈ
Mr.
ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾಗ ಬೈ ಕಂಡೋನಿಂಗ್ ದಿ ಡಿಲೇ,
Condoning the delay.
Yes,
yes,
Justice G. Narendra and Justice
Yes,
Nagaprasanna.
yes, yes, he was.
Narendra.
Justice Nagaprasanna is available.
Yes. No, Allah, I followed my lord what you lordship was saying.
You are now seeking
Yes.
to recall that order,
Recall that.
isn't it?
Yes.
So that application had to be considered only by the bench which has passed the order. Now the bench has to be reconstituted because one of them is available.
The modification
ಅದೊಂದು
ಕೇಳ್ದ-
problem.
modification ಕೇಳ್ದಾಗ that is, my lord, actually, my lord, what transpired on the last date of hearing was, my lord, I made a, my lord, submission that, my lord, if they make out a case for, my lord, reduction on merits, my lord, then there is question of, my lord, consideration of that delay or otherwise. My lord, my appeals, my lord, are in
Ah.
time.
Illi that delay has been condoned.
Delay has been condoned.
Ah.
My lord, we are in fact, my lord, ready with the condonation of delay and proceeding with the matter on merits.
Ah.
Our difficulty is, my lord, these matters are languishing unnecessarily, my lord, without making out a case, my lord, on merits. I made a submission that, my lord, let this be heard on merits. My lord, now that the delay is condoned, my lord, we have filed application for recalling.
Yes.
My lord, for a moment, let us assume that, my lord, we are not pressing those, my lord, applications as well. My lord, the matter is, my lord, now available for, my lord, this court to hear, my lord, on merits. It could be considered on merits, my lord, and then, my lord, that call could be taken.
So you want to argue the matter on merits?
Yes, yes, my
All
lord.
of you?
Yes, yes, my lord, yes.
That can
We'll
that
take.
can be done. We'll take
But-
up the matter on merits.
ಏನಾಗುತ್ತೆ ಅದು ನಾವು ಆ ಕಡೆನೂ ಇಲ್ಲ ಈ ಕಡೆನೂ ಇಲ್ಲ will not we are stuck with,
Just
we have
because
lost
of
our
the-
land.
But there is one problem.
Yes.
Once we proceed to hear the matter on merits,
Yes.
we cannot
Touch upon those limitation aspects.
ಇದಾಗೋದಿಲ್ಲ. We cannot touch this.
That's understood.
So you will have to give up your application.
ಹೌದು ಅಲ್ಲ ಇದು-
ಹೌದು.
Or else my submission is part of the matters are with condonation of delay.
The other part filed by my learned friend is without any continuation of delay and it is within the period of limitation.
ಅಲ್ಲ ಅವನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು.
ಅದೊಂದೇ ಅಷ್ಟೇ ಸೀರೀಸ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ರ that will- that
You,
will- that will form as a basis
you,
for the-
please give a list of only those matters which can be considered on merits. This problem is not there. ಯಾವ್ದ ಕೇಸ್ಗಳೆಲ್ಲ ಅದಿದೆ, please give a list, we will consider that on merits. Let us not touch upon these.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ my batch of appeals my lord are in time, the claimants appeal. Their batch of time, their batch of my lord matters are my lord beyond 120 days, but delay is not yet condoned. Delay is kept open, my lord. In all my cases where I have appeared, the delay is my lord kept open. It's not yet, my lord, the application is not yet
All right,
answered.
we can proceed
Proceed with those
to,
matters.
on the basis of the judgment of the coordinate bench.
How?
Saying that this is the view
Position of
taken,
How?
and therefore we will consider the matters on appeal.
Yes.
And we can dismiss the appeal filed by the state on the,
Delay.
on these lines. Anyway, they are taking up the matter
Yes,
before the
yes,
Supreme
yes,
Court.
yes.
Let them take these also. If there is any order passed in your favor.
Yes.
You give a list of only those matters.
Yes, my lord. I'll
We will
segregate
have
them.
it listed on second,
Please, ma'am.
we will have it
Yes,
listed on second.
yes.
Huh?
Right.
ಅದೇ ಗೊತ್ತಾಯ್ತು. ಆದ್ರೆ ನಾವು one thing is that we can't consider those applications.
Yes,
One,
yes, recalling application, my lord, your lordships, my lord, are finding
then
a
we will have
hurdle
to
to
await
consider. Yes.
orders of the Honorable Chief Justice. Other bench has to be constituted. Those applications have to be heard. So therefore, we'll segregate
Let them.
those matters.
What can be done is, my lord, all matters, my lord, wherever there are applications for recalling, that can be, my lord, segregated and listed separately.
ಅಲ್ಲ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ ಏನು ಮಾಡಿದಾರ ಅವರು ಹಾಕಿದಾರೆ ಈಗ. Let the law take its own course. Let us not say ನೀವು recall application ಹಾಕಕ್ ಬರಲ್ಲ.
ಇಲ್ಲ.
ಅವೆಲ್ಲ let us not consider that now. Since you are pressing that there are matters which can be heard without the problem of these,
Without any obstacles.
we will consider those matters and
But
dispose.
from the list, my lord, wherever there are applications for recalling, those matters have to be segregated.
ನೀವೇ ಕೊಡಿ, ನೀವು
ಆಯ್ತು, ನಾವು
ಮಾಡ್ಕೊಡಿ.
ಕೊಡು, ನಾವು ಕೊಡು.
We will say
One submission, my lord.
these appeals.
One submission,
ಕೊಡ್ತಾರೆ.
My lord,
But one submission, my lord. Serial number 25, my lord. Other day, my lord, learned AG appeared in these matters regarding the grant of the stay, my lord. These matters, my lord, your lordship is suggested that matter will be heard on final itself. That's why, my lord, Advocate General
That is what
requested,
we
my
are
lord,
going to do.
like 2 weeks, after 2 weeks, any date may be fixed, Ranta, that is the serial number 25, same thing, my lord, here also, my lord, same thing.
Ah.
There, my lord, we are permitted to deposit the amount there, 50%, that is already deposited. These all the fresh matters, my lord, serial number 25. There is a direction to, there is yet to be considered that IA is for stay.
ಹೌದು.
Then, my lord, we made the submission that another coordinate benches made the order, my lord, regarding deposit of 25% of the amount. We are relaying that one, my lord. Other side is, they are not relaying that one also. For that is the reason, my lord, your lordship is suggested last occasion, my lord, matter will be heard on final itself. Any date may be fixed.
ಇದ್ರದ್ದು ಈ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಲ್ಲ,
ಅಲ್ಲ, ಅದ್ರ
ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು
ಅಲ್ಲ,
ಕೆಲವು
ಅವ್ರು D-link
applications
ಆದ್ರೆ
ಹಾಕಿದಾರಲ್ಲ.
ಅದರ D-link ಆದ್ರೆ same, my lord, applicable in these cases.
That is
also.
what we are saying.
we
We are not pressing for this recall applications, my lord.
All
The delay
matters
be
could be heard.
condoned and let the matters be heard.
No, no. What my learned brother is saying is correct. It will set a wrong precedent. Allowing of the application for continuation of delay.
Is basically wrong.
ನಾವ್ ಅದನ್ನ if
Contrary to law ಆಗ್ತದೆ.
ಅಲ್ಲಿ ಅವ್ರ ಅಪೀಲ್ಗಳಲ್ಲಿ they have filed applications again seeking continuation of delay.
ಅಲ್ಲ, ಇವಾಗ ಅವ್ರ ಅಪೀಲೆ ಕಂಡೋನ್ ಆಗಿರೋದು ಸ್ವಾಮಿ, ನಮ್ಮ ಅಪೀಲ್ ಯಾವ ಕಂಡೋನ್
ಗೊತ್ತಾಯ್ತು. ಅದ್ ಬಿಟ್ಟು ಕಂಡೋನ್ ಆಗಿರೋದ್ ಬಿಟ್ಟು ಇನ್ನು ಕೆಲವು ಹಂಗೆ ಇದೆ. We are not prepared to
ಕಂಡೋನ್ ದೋಸ್ delay.
condone the delay.
ಹೌದು.
We said we will hear it.
Yes.
Now that the coordinate bench has passed this order, prima facie we see that this is correct and we will follow this. ಹಂಗಾದ್ರೆ we'll have to dismiss their appeals and then consider your appeal on merits.
Yes, that can be done.
We will do it if you are ready to argue
Yes,
on
yes.
those
I'm ready.
appeals where this problem of consideration of a recall is not there,
Yes.
we will consider that along with those appeals filed by the state where applications are pending consideration for condonation of delay. ಅದನ್ನು consider ಮಾಡ್ತೀವಿ.
ಆಯ್ತು.
ಎರಡು consider ಮಾಡುವಂತದ್ದು list ಕೊಡಿ, we will consider that.
After 2 weeks, my lord, any date may be fixed, my lord, that is the
Chandra,
request
again
by
they'll
the.
be-
ಇವಾಗ the understanding for today
Sir,
was
that-
that, my lord, they will come
ಅಲ್ಲ,
up. my
ಇವತ್ತು
lord.
ಆಗಲ್ಲ ಅಂತ is for
ಅಲ್ಲ,
some-
we will have it on second or third.
second ಅಲ್ಲ, 2 weeks ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, 2 weeks ದಲ್ಲಿ ಎನಿ ಡೇಟ್ ಮೇ ಬಿ 2 weeks ಅಂತ ಅವ್ರು ಹೇಳಿದ
Time
ರಿಕ್ವೆಸ್ಟ್
ಬಹಳ-
9th ಅಥವಾ 10th ಹಾಕ್ಬೋದು.
Dealing these matters from this batch of matters
I'll give you.
ಅಂತ ಆಡ್ಕೊಂಡು ಆ ಡೀಲಿಂಗ್ ಮಾಡಿರೋ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ಲಿಸ್ಟ್ ದೀಸ್ ಮ್ಯಾಟರ್ಸ್ ಆನ್ 9th of December 2024 ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂಡ್ ಡಿಸ್ಪೋಸಲ್ ಆನ್ ಮೆರಿಟ್ಸ್. ಎಸ್.
This may be issued my lord, separate list, my lord, because so many matters are there, my lord. 100 cases are there, my lord.
ಅದಿರ್ಲಿ, ಇಲ್ಲಿ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇರ್ಲಿ ಬಿಡಿ.
Please. Yes, my serial number, my lord, 25, my lord. 25, 28, 29.
ಅಲ್ಲ, these are, my lord, on a different
31,
issue, my lord.
32. These matters also, my lord.
ಸೀರಿಯಲ್ ನಂಬರ್
Serial number, my lord, 20.
Two.
ಹಾ 32 is ಅದನ್ನು ಬಿಯಾಂಡ್ 120 days.
Yes, ma'am.
Is all matters, my lord.
Yes.
Huh?
25, 31.
So 22 ಅಲ್ಲಿ that order we have passed, ಅದನ್ನ ನಂಬರ್ ಕೊಡಿ ಅಥವಾ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಸೇಮ್ ಆರ್ಡರ್ಸ್ ವಿಲ್ ಬಿ ಪಾಸ್.
Allah, that is why, my lord, regarding stay, my lord. Lord,
You
advocate
want,
Yes,
this can be linked along with
please.
the matters to be heard on 9th.
ಇಲ್ಲ, ಒಂದೇ ನಿಮಿಷ, my lord, they are trying to link, my lord, the cases which are unconnected. They are a different batch of matters, ಅದು separate ಆಗಿ ಬರ್ಲಿ. ಈ matters ಅಲ್ಲಿ their contention is stay subject to 50% ಕೊಡಬಾರ್ದು, stay subject to 25% ಮಾತ್ರ ಕೊಡ್ಬೇಕು
ಅದು
ಅಂತ.
ಬೇರೆ.
ಇದು this is on a different proposition.
ಬೇರೆ.
ಇದನ್ನ 2ನೇ ತಾರೀಕು ಹಾಕೊಂಡು your lordships, my lord, express that their the value awarded was 2 crore plus, ಇಲ್ಲಿ 7-8 ಲಕ್ಷ ಇದೆ, ಅದಕ್ಕೆ same proposition cannot be applied here ಅಂತ.
ಬೇರೆ.
ಹೌದು, ಇದು
Also
these
pay
are
it on
different
10th,
batch
my
of
lord,
cases.
not on the 9th, my lord, also pay out 10th, these
Allah.
matters.
But if they are all arising out of the same notification.
Yes,
No,
ma'am.
no, they are not.
Huh?
They are not.
ಇಲ್ವಾ?
Project
ಬೇರೆ
is same.
notification,
The
ಬೇರೆ
project is same.
project.
ಅದೇ ಬೇರೆ ಆದ್ರೆ let us
ಅಲ್ಲ, ಬೇರೆ ಬರ್ಲಿ, ಬೇರೆ ದಿವಸ ಬರ್ಲಿ.
separate. ಹಂಗೆ
Second-
separate
second-
orders we will pass.
Yes, please.
ಏನಂತ ಹೇಳಿದೆ ಅದ್ರಲ್ಲಿ? This is regarding that 25% or
ಹೌದು.
Okay,
6%?
please, my lord. Please.
ಅಲ್ಲ, ಅದನ್ನ 50% ತಾವು ಮಾಡ್ಬಿಡ್ಬೋದು ಸ್ವಾಮಿ. ಬೇರೆ ಕೇಸಸ್
Relax
ತಾವೇ ಆಲ್ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
We have put it to the learned advocate general.
Yes.
That this is what we find, you will have to convince us.
ಹೌದು.
Why now that the standard
Ah.
should be lowered to
Lowered.
25%, because all these years we have consistently held that 50% has to be deposited.
ಇದನ್ನ let that be heard, my lord, on it, because it was a date chosen by the AG, my lord.
So,
ಅವರು
ಹೇಳಿದ್ರಲ್ರಿ,
ಅಲ್ಲ, that's why, my lord, you will also.
was
have
his
10th, my
choice
lord,
of date, my lord, which
You will
was
also
given.
separately, my lord, have it on 10th, my lord, December. Merit ಮೇಲೆನೆ ಮಾಡ್ಬೋದು ಅಂತ ತಾವು ಸಜೆಷನ್ ಕೊಟ್ಟದಕ್ಕೆ they are,
Date of, last date of.
merit ಮೇಲೆ,
ಅಂತಾನೆ ತಾವು
ಅಂದ್ರೆ
ಸಜೆಷನ್ ಮಾಡಿದಕ್ಕೆ.
without going to the question of stay,
Yes,
we can consider the matter on merits and
correct.
dispose of ಅಂತ.
ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ. ಇವಾಗ
Delay.
ಕಷ್ಟ ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅವ್ರ ಮೆರಿಟ್ ಮೇಲೂ ಹೋಗಕ್ ರೆಡಿ ಇಲ್ಲ, ಡಿಲೇ ಮೇಲೂ ಡಿಸ್ಮಿಸಲ್ ತಗೊಳಕ್ ರೆಡಿ ಇಲ್ಲ.
Problem, ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Lords have 10th, my lord, let him, my lord.
No, we will reject the application.
ಅಲ್ಲ, ಅಲ್ಲ.
We reject the application, we will dismiss the
ಅಲ್ಲ,
appeal.
because, my lord, there is so many, my lord, the matters are there, my lord. For that is the reason, my lord, lordship posted today, my lord, for hearing the advocate general, my lord, on this point only. But today, my lord, some inconvenience,
No
my lord.
question of continuation of delay.
That's why, my lord, you will address your lordship.
That,
my lord, that's
that
why.
issue has been decided by the coordinate
But
bench.
that's why, my lord, that is preferred the SLP, my lord, that is
ಆಯ್ತು,
pending.
ಮಾಡ್ಕೊಂಡು ಇದು ತಗೊಂಡೋಗಿ
ಅಲ್ಲ ಇದ್ರನ್ನ ಅವರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ.
ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ?
You will address the argument. That is why I requested me to take some time ಅಂತ ಹೇಳಿದ್ರು.
Last time I had the request.
We
of
were
the-
about to say, no, we'll consider this matter on merits.
ಅಲ್ಲ you were not
But this problem arose
Out.
and therefore we said, no, it cannot be considered on merits.
That's why, my lord, he requested. Today, my lord is not unable to appear before lordship. But that is the reason, my lord.
ನಾಳೆ Monday.
Any other day, my lord, on 10th, your lordship have it, my lord. Not 9th, my lord, 10th, your lordship.
Tomorrow day after
Next
ಅಲ್ಲ,
week,
ಅವ್ರು
next week,
he is not-
please come on 3rd of December.
Great.
Third of December. It is only on this point ಅಷ್ಟೇ.
Second ಹಾಕ್ಬಿಡಿ.
Not on the merits.
Lordship have second, my lord.
Second, all right. Serial number 22.
22, 25,
Hmm.
28, 29, 31, and 32.
32.
39.
Notification ಬೇರೆ, but this question, all this will go only on this ground that no question of continuation of delay.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಆಗಿದೆ. ಆಗಿಲ್ಲ. 39 also, my lord. There is no order, my lord.
ಅದೇ.
ಇಲ್ಲ ಇದು 55 days ಒಳಗಿದೆ 60 ಒಳಗಿದೆ 55 days those sections 74.
ಹೌದು, 39.
See, it is also possible
Please.
that we are also indicated last time. If you are willing to deposit 50%, we will pass the same orders.
That's true, my lord. That is the problem, my
As we
lord.
had passed in the other
Yes,
matters,
but that is true, my
that
lord.
the application, consideration of the application will be kept pending.
But that's-
But in the meanwhile, you deposit 50%.
On that time, my lord, you will make submission, my lord.
Yeah.
Please.
ಎಲ್ಲಾದ್ರಲ್ಲೂ release this matter on 2nd of December. Yes.
Actually, my lord, he sought 2 weeks time, my lord.
Huh?
2 weeks, my lord, he requested me.
That is to argue on merits of the matter.
ಅಲ್ಲ,
We can't
ಇದ್ರಲ್ಲಿನೂ ಕೂಡ
consider
ಅವರು
on
2
merits.
weeks ಅನ್ನ ಕೇಳಿದ್ರು.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Yes.
Serial number 21 RS Siddhapurkar.
May I kindly pass over this matter? ASI is writ appeal.
Huh?
Kindly pass over your lordships. May be taken up at 2:30.
Contempt.
21.
Conversion.
21
Yes, yes, in this matter, my lord. 21.
21.
20.
Siddhapurkar sir or sir.
Writ appeal is filed
In this matter, my lord, what happened last occasion, my lord?
KLR conversion.
Yes, yes, ma'am.
Your lordship.
This is with regard to my lord archaeological survey of
Conversion.
India,
Yes.
where my lord they have undertaken to do survey.
Lord, the officer has come today. Can it be taken up at 2:30? Can it be taken up at 2:30?
2:30.
In this matter, my lord, I.
Officer
permit
has
me
come
Make
now.
submission, my lord. In this matter, my lord. But last occasion, your lordship has noticed that, my lord, there is no objection to the, my lord.
Correct.
give the
Some other.
permission.
Very land.
But we found out that, my lord, it is coming under the, my lord, that jurisdiction only.
ಹೌದು, we have noticed.
Yes, that's why, my lord, we written
Therefore,
letter.
they are required to answer.
Yes, we written letter to them, my lord.
Ah,
Why you issue the no objection?
Correct.
That's, my lord, we written.
but, how will they substantiate now?
That's why, my lord, that we intimated to them also, my lord. That's why, my lord, we cannot, my lord, if we converted also, you will not permit to put up the construction also. That is a problem. It happened in the, my lord, supermarket.
ಏನಾಗಿದೆ
area.
ಅದೆಲ್ಲ ಮುಂಚೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ,
ಅದು ಧಾರವಾಡ ಸರ್ಕಲ್ ನಿಂದ ಇಶ್ಯೂ ಆಗಿದ್ದು.
ಅಲ್ಲ ಏನೇ ಆಗ್ಲಿ,
ಕೊಟ್ಟಿದ್ದ?
ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? They proceeded with the construction?
No, it is for approval of layout. NA and approval of layout.
Correct. After
Construction,
you gave NOC, have they
construction ಆಗಿಲ್ಲ.
proceeded?
ಇಲ್ಲ.
Huh?
ಇನ್ನೂ ಆಗಿಲ್ಲ.
We are not
ಆಗಿಲ್ಲ.
given the permission, my lord. We are not converted to that land also. That's why, my lord, we written.
So,
this letter.
though permission was given,
Yes, my
in
lord.
some cases,
Yes, my lord. We not given the.
you have
permission.
refused to.
Yes, refused.
Sorry, mat.
No, no,
My lord,
it-
we written letter to him also.
I have submissions to make, my lord. I have submissions all along, my lord. Since, my lord, more than, if I am correct, my lord, 6 to 7 times, they have taken adjournment stating that they are going to conduct, my lord, one more survey. But still they are not doing. That apart, my lord.
ಮ್ಯಾಪ್ ಅಲ್ಲೇ ಕ್ಲಿಯರ್ ಆಗಿ ಗೊತ್ತಾಗುತ್ತಲ್ರಿ.
My lord, therefore,
ಹಾ.
why, my lord, this court said so, it is because materials placed on behalf of, my lord, the respondents hearing. May I request for a moment, lordship, there are abundant material where, my lord, NOC is issued by archaeological
ಮತ್ತೆ
department.
ಅದೇ ಹೇಳ್ತಿರಲ್ರಿ, though NOC was given by them, the competent authority has refused to convert the land. So therefore, nothing has happened.
It is only in respect.
What is the use of
Yes.
their NOC then?
Yes, yes, ma'am. It is only in respect of recent, my lord, the order what I have passed before your lordship other day. It is only in respect of that land. But what I am saying, my lord, may I request for a moment, my lord. My objections may be taken into note. Rule itself contemplates that, my lord, prohibition is with a certain degree, my lord. Certain degree, my lord, that is 100 meters. May I request for a moment. My statement of objections. There, my lord, there is rules act called, my lord, the ancient monument and archaeological sites and remain amendment so and so 2010.
Objections
My lord, it is filed on 22nd March 2022.
in the writ appeal.
Yes, ma'am. Yeah, 22nd. May I request lordship to peruse page 8, my lord, of page 8, section 20A. Every area beginning, may I read?
One ನಿಮಿಷ ಇರ್ರಿ.
Sorry.
Page 8.
Page 8, ma'am. Yes.
Ah.
Section 20A.
Ah.
Prohibited and regulated areas. Every area beginning at the limit, may I read, of protected area or protected monument. 20A, my lord.
Last portion, ಕೆಳಗಡೆ.
Last.
Page, ink page 8.
Every area beginning at the limit of protected area or the protected monument, as the case may be, and extending to distance of 100 meters in all directions shall be prohibited area in respect of such protected area or protected monument. Now, may I request lordship to peruse annexure R2, my lord, page 18. There, very Deputy Superintendent Archaeologist, Dharwad Circle, Dharwad. They, my lord, measured the distance in between, my lord, monument and the survey number, my lord, 401/4. Distance between, may I read top, my lord, in the top. Distance between survey number 395, ancient mound, Suli Dibba, and survey number 401/4 at Muskie is 1.8 kilometer, that is 1235 meters. Distance between 400 Ashoka Shila Shasana and survey number 401/4 at Muskie is 2.31 meter, that is 1081 meter. This is issued by very same department. And may I invite lordship's attention to annexure R3, where in respect of 401/1, in respect of 401/1, annexure R2, my lord. Superintendent, it is an communication, office communication.
R3.
Annexure R3, page 19, my lord. It is office communication by Superintendent Archaeologist to, my lord, competent authority and reasonable commissioners, Belgaum. There, my lord, with reference to, may I read, with reference to your letter dated so and so, I have honor to inform you that after inspection of proposed site bearing number so and so, Linksgur by the technical team of this office, it is found that the proposed site for construction in survey number 401/1 at Muskie Taluk Linksgur is well beyond the regulated area of so and so from the protected limits of centrally protected monument of ancient mound and Ashoka inscription respectively at Muskie. Since Archaeological Survey of India has nothing to do with this matter, as the proposal is beyond the purview of Archaeological Survey of India, the application submitted by Srimati so and so is hereby returned along with enclosures, including Google image for necessary action. And my lord, may I request next, take lordship to next annexure R4. This also refers to, my lord,
Then how did you,
Yes.
Mr. Government Advocate?
Please.
May I make one more submission. This is all, my lord, in respect of these, my lord, lands what I have referred now, my lord. Constructions have already come up. And may I take my lord lordship to annexure R7, page 23. This is issued by very deputy commissioner office converting the land in respect of my lord survey number 401/3. 401/4.
That you are now saying, no, it's not
The
considered.
statement of objection is filed, my lord, not served to me, my lord. If he served, my lord, I'll get the instruction from the deputy commissioner.
Today,
I'll-
the statement of
Yes,
objections.
yes.
today.
And lordship has already taken note, my lord.
In our previous order, we had noticed the submission made on behalf of the learned counsel for the respondent. Contesting respondent that NOCs have been issued by the Department of Archaeology in respect of
402, my lord.
survey numbers 402/1,
125.
402/2, 402/3, 402/4, and 402/5. And that the authorities are now refusing to grant NOC in respect of similarly situated lands. Full stop. We had therefore directed the learned counsel for the appellant to secure instructions as to whether the statement made by the learned counsel is true. Full stop. Next para. Learned government advocate today submits that although it is true that NOCs were earlier issued by the Department of Archaeology, nevertheless, the Deputy Commissioner and competent authority to consider an application for conversion of the lands in terms of section 95 of the Karnataka Land Revenue Act has refused to convert the lands. Stop. Next para. To this, learned counsel for the contesting respondents has drawn the attention of this court to the material placed along with the statement of objections and submits that various orders passed by the Department of Archaeology, clearly stating that the distance between the archaeological sites and survey numbers 401 were beyond the prohibited distance of 100 meters. Full stop. In fact, it is found that these survey numbers are beyond 1 kilometer, if not more. Full stop. Further, orders of conversion have also been enclosed along with the statement of objections. Full stop. Next para. Having regard to these admitted facts, the appellants are now required to file an affidavit along with a sketch showing the distance between the archaeological site and the lands in question, namely, yaudri indu
401/1, my lord, and 401/7. Isa 7,
or not?
1/1
Ah,
and 401/7. There are two appeals in two appeals.
stop. Relist these matters on 3rd of December. Yes.
May I make one request, madam? Even deputy commissioner may also able to,
ಅಲ್ಲ ಬಿಡಿ ಅವ್ರು ಅವ್ರು
Please.
ಏನು ಅವ್ರು ಕೇಳೋದೇ ಬೇಕಾಗಿಲ್ಲ.
please.
If they given no objection,
Distance is
Yes, yes,
clearly
yes.
beyond 100 meters
Great,
and NOC is given.
yes,
They are bound to consider
yes,
because similar orders have already been
yes,
passed.
yes. Great.
Public.
Serial number 23, Shivanand Patil.
Prepare for the appellant.
Yes.
It's, the petitioner, my lords, the appellant and respondent number 5. Both had applied, my lords, for the post of Anganwadi helper.
ಯಾಕೆ ಇವ್ರು ಬಂದಿಲ್ಲ? ಅವರು ಹುಲೆಪ್ಪ ಹೆರೂರ್.
For respondent number 5.
So stay order is already passed.
Stay is passed by this honorable.
Matter is called out. There is no representation for respondent number 5 who has filed application in IA number 1 of 2024 seeking vacate the order of stay. Full stop. Next para. Release this matter on 3rd of December.
Notes third, I have some personal inconvenience.
Oh,
Third,
bondu.
fourth, fifth.
Yes,
Now, you proceed,
we can dispose of the matter itself.
please.
We are not hearing on IA.
Please, please.
Yes.
Appellant as well as respondent number 5. It's had made an application, my lords, for appointment of
Anganwadi helper.
Anganwadi helper.
Ah,
In fact, in the court below, my lords, before the single judge court, the writ petition came to be disposed of in a view.
petitioner has scored 515 marks
Yes, my lords.
out of 620. Respondent has scored 495.
That is not my dispute, my lords. In
Ah.
fact, my submission before this honorable court is that the very application made by the respondent number 5 is not maintainable in light of the document which they have produced. Annex A is the, my lords, the guidelines prescribed for the selection process. In fact, it is of the year 2014 and the appointment
The writ petition filed by
Myself,
Number five.
myself,
is
myself.
allowed.
allowed.
Yes, my
You
lords,
are
that is
questioning.
allowed.
Yes,
The aggrieved party being respondent number 5 before the
yes,
court.
yes.
Annexure A, my lords, is the guidelines prescribed for the selection process.
Yes.
In fact, it is of the year 2014, which, my lords, is necessarily could not be considered. So I also filed an application, my lords, along with additional documents.
Ah.
Additional document number 1,
Ah,
lords, that is, lords, the government guidelines for Anganwadi helper recruitment. The very first document, my lords.
Adhisoochane.
Adhisoochana. That is the application, my lords. That is the notification,
Calling-
my lords,
calling for
calling for the
application.
appointment of Anganwadi helper.
Ah,
And thereafter, my lords, in which, my lords, it is reflected that the last date for making an application is 31/7/2021.
ah.
Thereafter, my lords, the petitioner, my lord, the appellant as well as respondent number 5 makes an application on prior to 31st. That is not in dispute. Thereafter, my lords, it was specifically stated that all certain documents which were required to be produced, that should not be an acknowledgement or a free copy of the very same. On the very next page, my lords, if your lordship may kindly find out at 67, page 67 ಅಲ್ಲಿ. Serial number 4 ಅಲ್ಲಿ. For a document, my lords, that is residential certificate. ತಹಸೀಲ್ದಾರ್ ಉಪ ತಹಸೀಲ್ದಾರ್ ಪಡೆದು 3 ವರ್ಷಗಳೊಳಗಿನ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ, ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ಸ್ವೀಕೃತಿ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಹಾಗೂ ಉಚಿತ ಪತ್ರ ಫ್ರೀ ಕಾಪಿ ಪತ್ರಗಳನ್ನು ನೇಮಕಾತಿಗೆ ಪರಿಗಣಿಸುವುದಿಲ್ಲ.
You have
That
to give a
cannot be
certificate
considered.
only.
Yes, my lords. The very certificate, my lords, has to be considered.
Yes. So ಅವರು ಬರೀ acknowledgement ಹಾಕಿದ್ರಂತ.
ಹೌದು, acknowledgement ಮಾತ್ರ ಹಾಕಿದ್ರು. That is my only submission before this court. In light of that acknowledgement, my lords, the very application was not maintainable.
So that is
That
why
very, that very objection was.
that is why it was rejected.
Yes.
That is why it was
Yeah, that is
rejected.
why it was rejected. Earlier, she was appointed, and thereafter I raised an objection that, my lords, all the documents which she has produced, my lords, the genuinity of such documents has to be considered. In light of that, my lords, her appointment was set aside, and my lords, I was the next meritorious candidate to, my lords, to have been selected for that post. Upon which, my lords, they had preferred the writ petition. The very application itself is not maintainable. Annexure F ali,
Then why did you not argue this matter before the learned
lords,
single
the very
judge?
same thing, my lords, was put forth before the court, although
If it was not about marks and it was something else.
my lords, orally it was put forth. My lords, I consider that, my lords, my earlier counsel had not made that objection, my lords, filed any objections. But then, my lords, the very same contention was taken before the.
Where is
court. That
this discussion
was- that
by
is
the
not-
authorities
Yes, my lords, that
considering your objections?
that authority, my lords,
Where is that order?
order as per annexure. Annexure M.
Page number?
It is at page number 51 of my writ appeal, wherein her appointment, my lords, was withdrawn.
ಓದಿ.
ಉಲ್ಲೇಖ ಒಂದರ ಸರ್ಕಾರಿ ಆದೇಶದ ಪ್ರಕಾರ ಬೀದರ್ ಯೋಜನೆಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಅಂಗನವಾಡಿ ಕೇಂದ್ರಕ್ಕೆ ಸಹಾಯಕಿಯನ್ನು ಗುರುತಿಸಲು ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿ, ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಶ್ರೀಮತಿ ಶಿಲ್ಪಾರಾಣಿಗಂಡ ಸ್ವಾಮಿದಾಸ್ ರವರಿಗೆ ತಡಪಳ್ಳಿ 2ನೇ ಅಂಗನವಾಡಿ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಅಧ್ಯಕ್ಷರ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆಯರ ಸಹಾಯಕಿಯರ ಆಯ್ಕೆ ಸಮಿತಿ ಬೀದರ್ ಅವರು ಅನುಮೋದನೆ ನೀಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಆಕ್ಷೇಪಣೆ ನಂತರ ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಶ್ರೀಮತಿ ಶಿಲ್ಪಾರಾಣಿಗಂಡ ಸ್ವಾಮಿದಾಸ್ ರವರ ಅಂಕಪಟ್ಟಿ ಪ್ರಮಾಣ ಪತ್ರದ ನೈಜತೆ ಕುರಿತು ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ಕನಿಷ್ಠ ಗರಿಷ್ಠ ಅಂಕಗಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 5ರಲ್ಲಿ ಸದರಿ ಕೇಂದ್ರಕ್ಕೆ ನಂತರ ಅಭ್ಯರ್ಥಿಯಾದ ಶ್ರೀಮತಿ ಪ್ರೇಮಲಾ ಗಂಡ ತುಕಾರಾಮ್ ರವರಿಗೆ ಅಂತಿಮ ಆಯ್ಕೆಯನ್ನು ಮಾಡಿ ಆಯ್ಕೆ ಸಮಿತಿಯು ಅನುಮೋದನೆ ನೀಡಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಸದರಿ pardon, my lord.
Where are the reasons?
The reasons, my lords, is as per one inquiry conduct ಮಾಡ್ತಾರೆ, my lords. In that inquiry, it is found that that such document, my lords, that reasons are not forthcoming, my lords. Prima facie, my lords, the very document acknowledgement which he has produced, that, my lords,
Where do
cannot
you
be.
get all this information?
Pardon, my lords.
From where do you get all this information?
Lords, that is as per their annexure A itself. The document has to be genuine anta adralli. I draw your lordship's attention to page. Page 33 ಅಲ್ಲಿ.
ಏನು 33 ಅಲ್ಲಿ?
ಅಲ್ಲ ಆಯ್ಕೆ ವಿಧಾನ ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ, my lords, that
ಹೌದ್ರಿ, on facts, what you are saying, where do you get all that information from?
lords,
ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ that she had filed only acknowledgement.
yes, my lords, lordship may kindly find. Annexure F ali, they have submitted, my lords, that their residential certificate,
Page number ಹೇಳಿ.
page number 39 ಅಲ್ಲಿ. Her residential certificate was issued on 17/8/2021.
Date?
17/8/2021, page 39 of my writ appeal, annexure F.
Date ಎಲ್ಲಿದೆ?
Date ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದೆ. Page 39 ಅಲ್ಲಿ, left hand side,
17/8/2021.
21.
ಹಾ.
She, my lord, says had preferred the application before 31st
31st of?
July 2021.
ಹಾ.
And in application page number 35 ಅಲ್ಲಿ, she has wrongly mentioned that, my lord, her residential certificate dated 37/2021. 35 page number.
Application ಇದು.
ಅವ್ರದ್ದು application ಇದೆ, online application.
Residence certificate. ಅದ
Issuing date ಇದೆ ಅದು.
ಹಾ?
actually. Issuing date is on 37/2021 ಅಂತ mention ಮಾಡ್ತಾರೆ.
ಇದು ತಪ್ಪಿದು.
ಹೌದು.
Wrong information.
That is wrong information.
information.
Wrong information produced to the notes department. Insofar as the certificate is concerned, that was particularly issued on 17/8/2021.
Yes. Yes, Mr. Perur.
Blood. This is the application filed online, annexure B, page number 35. As per this, my lord, online application is made
Yes.
accordingly, and I have been issued with appointment order.
Correct.
There is no dispute about anything.
Yes, yes.
My lord will find annexure G, page number 40. That is the appointment order.
Correct.
After appointment, I worked for 9 months.
Hmm.
Till 9 months, there was no whisper from anybody, even the appellant. Now, my lord, when I assailed my withdrawing the appointment before this honorable, before learned single judge, matter was agitated at length. Finally, this learned single judge ordered chief secretary to file an affidavit as to which one is the correct. 625 out of 625 is correct. Out of
Officer ಅಲ್ವಲ್ಲ ಇದು.
huh?
This is not about marks.
No, they were very.
That is what the learned council is saying.
The
This was
dispute.
not an objection regarding
this
the
objection-
marks.
This
The
objection was
objection was regarding your non-furnishing of the certificate in accordance with the requirement of law.
true, my lord. True. This dispute, nor this objection was never raised at any time, at any point of time.
Hmm?
Now that he is raising, I will produce, I will be granted 2 days time. This never, nobody, nor authorities,
Government advocate.
nor authorities. Kindly, if my lords call for the
Look at the
records.
records.
Required to get the original records to show ಅದ್ ಯಾವ್ದ್ರಿ ಅದು ಆರ್ಡರ್ ತೋರ್ಸರಲ್ಲ ನೀವು
Annexure M.
recalling the
Withdrawing the appointment order.
Appointment
Annexure
is
M.
at,
annexure
page
M.
51, annexure
Come
M.
page number 51.
ನಿಮ್ಮ ಹತ್ರ ಪೇಪರ್ಸ್ ಇಲ್ವಾ?
File ಆಗ್ಬಿಟ್ಟ file.
ಫೈಲ್ ಬಂದಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Learned government advocate is directed to secure the original records. From the respondent authorities. More particularly. The reasoning furnished by the authorities for recalling the order of appointment
Withdrawing ಅಂತ. Withdrawing the order of appointment.
in terms of annexure M dated
18/7. 18/7/22. Second half of the page.
18/7/2022. So annexure M is an order passed by the assistant director of the Department of Women and Child Welfare, Bidar,
Deputy Director.
Deputy Director.
Deputy Director. cancelling the order of appointment, which was earlier made in favor of respondent number 5 herein. Full stop. However, no reasons are forthcoming in the said order. Therefore, we are constrained to call for the records. Full stop. Next para.
After having served for 9 months.
Sorry, we will consider. We want to see
The genuinity of the.
whether this was the ground on which your order was cancelled.
I,
Let us see
Lords,
what
I
we-
had specifically, Lords, made an objection in that regard. I had also made a written objection, Lords. I'll also file along with
filed.
the memo. No, I'll file
Objection
it
not
today.
filed.
No, I'll file it today, Lords.
ಏನದು?
Kindly- ಅಲ್ಲ ಇದ್ರಲ್ಲಿದೆ ನಾನು ರ್ಯಾಂಡಮ್ ಆಗಿ ತಗೊಂಡಿದ್ದೀನಿ ನಾಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಅಬ್ಜೆಕ್ಷನ್ But then in-
ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ತೀವಲ್ಲ ಎಲ್ಲ ಸಿಗುತ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಪ್ಲೀಸ್
Release this matter on 3rd of December.
third Lords, I have some personal inclination.
ಹಾ.
3, 4, 5 ಬಿಟ್ಟು
Ninth, your lordship at ninth, my
4,
lord.
5 and ಬಿಟ್ಟು
ಹಾ?
any other date other
Ninth
than
ticket ಗೆ ಮಾತ್ರ.
ಏನ್ರಿ ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸೋದು ಅಷ್ಟೇ ಅಲ್ವೇನ್ರಿ?
3, 4, 5 and 5 Lords.
ಹಾ?
Other than 3rd, 4th and 5th, any other day.
So 9th of December.
Oblige. Writ appeal, 14.
Seal number 24, Manvendra Reddy.
Interim order granted earlier stands extended till the next date of hearing. ಇದೆ ಇದ್ರಲ್ಲಿ.
Seal number 23.
It's an interim order. Please. Oblige.
Seal number 24, Manvendra Reddy.
It's an appeal for challenging a liability, my lord. There is a delay of 37 days in filing the appeal.
But you are ready to deposit 50%.
50%.
Huh?
50% will deposit. And
ಅಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ ಆಗ್ಲೇ.
There is no stay.
ಹಾ?
There is no stay, my lord.
no stay. My application is pending. Delay is the
Order on IA number 1 of 2022. Delay of 37 days in filing the appeal is condoned. Full stop. However, the appellant is directed to deposit 50% of the award amount before the tribunal
this
within a period of 6 weeks from.
Kindly
before
permit
this
me,
court,
ಬೇಡ ಅಲ್ಲಿ
kindly permit me to withdraw the amount, my lord.
liability question ಮಾಡಿ.
very
ಅಲ್ಲ.
liability involvement is called in question.
ಅಲ್ಲ 2023 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಾರೆ ಇನ್ನೂ ತನ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್
ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ನಾವೇನ್ I was moody.
ಅಲ್ಲ ನಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್
Kindly-
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. We can dispose of the appeal
Yes,
itself.
ma'am.
We will
We
not.
Will
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
ಸರಿ ಮತ್ತೆ. If you are ready with the matter, we will consider.
next week will any date, man.
One date may be given, my lord.
Yes, I am ready.
Same.
Release this matter on 4th of December.
Stay, man.
Hmm?
Stay ಆಗಿಲ್ಲ.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತಲ್ಲ.
Stay.
ಏನಂತ ಹೇಳಿದ್ವಿ?
ಅಲ್ಲ.
ಆಗಿದೆಯಾ? ಆಗಿದೆ ಅಂತಲ್ರಿ?
Such a deposit being made, it shall be kept in the FD. National Bank for period of 3 years.
Sorry.
ಆರ್ಡರ್ ಆಗಿದೆ ಹಂಗಾರೆ.
ಹೇಗಿದೆ
ಬೇಡ
sir?
ತೆಗೀರಿ. ಅದು ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಷ್ಟೇ.
Stay ಕೊಟ್ಟಿಲ್ಲ, but
ಸ್ಟೇ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ, delay ಐತೆ ಅಂತ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಎನಿವೇ
ಆಯ್ತು.
ಗಿವನ್ ಡೇಟ್
Yes, yes.
ಯು ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂಡ್ ಡಿಸ್ಪೋಸ್.
ಮಾಚು.
ಡಿಲೇ ಕಂಡೋನ್ಡ್ ಅಷ್ಟೇ.
Seal number 26, Mantesh Patil.
The office has raised an objection regarding the maintainability of the,
husband is no more.
How?
Husband is no more.
how,
Huh?
no, my lords, this is not that case. This is not that case.
ಅದೇ that is why
ಇಲ್ಲ ಇದರಲ್ಲಿ
husband is no more.
Now what the dispute is that, my lords, the appellant herein is claiming as a, my lords, wife of one G. Narsanna. And the defendant, my lords, in the suit, she is claiming as a, my lords, she is the wife of one Narsareddy.
Adhe re, husband is no more.
House.
That is what we said.
Husband is no more. Now the dispute, my lords, in respect of the marital status with the person who has died is in dispute, my lords.
Suit was filed
Yes, my lord.
by the
To declare
appellant herein.
Appellant herein.
Narsamma against Rajamma.
Against Rajamma, decree for declaration to be passed that the
My lord, serial number 27 IFF for appellant. My lord, we have deposited the amount before the executing court, my lord, on 24/8/2024, my lord. But the camera and audio of the court is muted, my lord.
Serial number 26,
I can only see. I'm sorry, my lord. I'm sorry, my lord. Yes, my lord. Now it's audible.
Serial number 26. We are in serial number 26. Yes.
my lords, save as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure or in the Code of Criminal Procedure 1973 or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court both on facts and law. And the further no appeal shall lie from a decree or order passed by the family court with the consent of parties or from an order passed under chapter 9 of the code, that is 125 proceedings. My lords,
Civil Courts Act.
the first in the clause 1 itself, my appeal is maintainable. Because it's an order passed by the family court and the suit came to be disposed of.
Not being
interlocutory order.
an interlocutory order.
Yes. Not being an interlocutory order.
Yes.
And if the order, my lords, disposing or terminating the original proceedings, that becomes the final order, my lords. It's an settled legal position. Because I can't maintain, it can't be treated because the proceedings itself has ended in final disposal.
Yes.
And my lords, the may I, my lords,
Objection regarding office objection regarding maintainability of the appeal is considered. Full stop. Learned counsel for the appellant. Submits that Section 19 of the Family Courts Act, 1984 provides for an appeal from every judgment or order, not being an interlocutory order, of a family court to this court, both on facts and on law. Stop. Learned counsel submits that the order impugned is not an order, not an interlocutory order. Full stop.
CPC.
After completion of the pleadings, issues were framed by the family court, and issue number 5 was ordered to be taken up as preliminary issue. Full stop. Issue number 5 as framed by the family court is, open commas, whether this suit is maintainable under law in this family court, question mark, close note, comma. The family court has proceeded to hold that the suit is not maintainable before the family court and has accordingly ordered return of the plaintiff. Stop. This order cannot be considered as an interlocutory order. Stop. You are
It is reported in AR 2018 SC 786. Just may I use it? See the judgment relied on by the family court not to hold that the suit is maintainable, not maintainable. My lords, may I request your lordships para 1 ಅಲ್ಲಿ the prayer sought in that in those proceedings was. The first prayer in respect of the claimed as a plaintiff is a legally wedded wife. Second, my lords, 2 to 4 are claimed as a legitimate children of first plaintiff and late Gunshan.
Declaring that the first plaintiff is the legally wedded wife of deceased Gunashilan. Same. ಇದೇ ತರ ಪ್ರೇಯರ್.
ಇದೇ ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಕವರ್ ಆಗಿದೆ. ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಅವರು ಫರ್ದರ್ ದೇ ಹ್ಯಾವ್ ಕ್ಲೇಮ್ಡ್ ಮಾಲರ್ಸ್ ದಿ ಪಾರ್ಟಿಷನ್ ಅಂಡ್ ಫಾರ್ ಡಿಕ್ಲೇರಿಂಗ್ ದಟ್ ದೇ ಆರ್ ಲೆಜಿಟಿಮೇಟ್ ಚಿಲ್ಡ್ರನ್ plaintiff number 2 to 4
are legitimate legitims to children of
first plaintiff and late Gunshan,
declaring that the first plaintiff as wife and plaintiff number 2
as
children and third defendant as mother. ಎಲ್ಲಿದ್ದಾರೆ ಸೂಟ್ ಪಾರ್ಟಿಷನ್
ಲೀಗಲ್ ಏರ್ಸ್ ಆಫ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಕೇಳಿ
ಪಾರ್ಟಿಷನ್ ಅಲ್ಲ ಏನು ಕೇಳಿ
ಪಾರ್ಟಿಷನ್ ಕೇಳಿ ಮಲಾಟ್ಸ್ ದಿ ಕೋರ್ಟ್ ಹೋಲ್ಡ್ಸ್ ದಟ್ ಪ್ಯಾರಾ 7 ಅಲ್ಲಿ ಪ್ಯಾರಾ 7 and 8 the above would indicate that the dispute between the parties is a purely a civil dispute and has no bearing on any dispute within a family which needs to be resolved by a special procedure as provided under the Act. No issue with regard to the institution of marriage and the need to preserve the same also arises in the present case. That apart, the dispute between the parties can only be resolved on the basis of evidence to be tendered by the parties, admissibility of which has to be adjudged within the four corners of the provisions of the Indian Evidence Act 1872. In such a proceeding, it would be clearly wrong to deprive the parties of the benefit of the service of the counsels. Taking into account all that has been said to above, we are of the view that the High Court was not correct in holding that the suit filed by the plaintiff appellants to be maintainable in law. Accordingly,
not maintainable in law.
In law. Also, not maintainable in law.
Taking into account all that has been said about,
we are of the view
that the High Court was not correct
in holding that
suit
filed by the plaintiff
appellants
to be not maintainable.
Not maintainable. Andre it is maintainable anta Supreme Court is saying. Facts was
facts. So I will direct note.
Paragraph number 2.
Paragraph. The suit was filed in a situation where the legal heirship obtained by the plaintiff's appellants was sought to be challenged by the defendant number 1 and 2, who claimed to be the wife and son of late Gunshan, whom the plaintiff number 1 also claimed to be her husband.
But whether the suit is maintainable before the family court or the regular
civil court, regular civil.
ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಕಿದಿತ್ತು ಅದನ್ನಲ್ಲಿ ಆ ಕೇಸ್ ನಲ್ಲಿ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಕಿದಿತ್ತು. ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಮಾಡ್ತು.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
In the civil suit in the court of civil court Madras.
The judgment that the learned counsel is reading ada.
Para 3 dalli.
ಅದೇ ಪ್ಯಾರ.
ಓದಿ paragraph number 2.
The suit was filed in civil court.
No, let us. Yes.
Not sir. I will read from para 3 or para 2.
Para 2.
2 in. The suit was filed in a situation where the legal heirship obtained by the plaintiff's appellants was sought to be challenged by the defendant number 1 and 2, who claimed to be the wife and son of late Gunshalan, whom the plaintiff number 1 also claimed to be her husband. The suit was decreed by the learned trial court, which decree was affirmed in the first appeal. The High Court in the second appeal took the view that having regard to the nature of the suit and the reliefs claimed, the civil court had no jurisdiction to entertain the suit, which lay within the domain of the family court, constituted under the Family Courts Act 1974. Accordingly, on the aforesaid basis, the decree has been reversed. The objects and reasons behind the enactment of the act, which is reproduced here in below, would suggest that the reason for constitution of the family courts is for the settlement of family disputes. If possible, by pre-litigation proceedings, if the dispute cannot be settled the same as to be adjudged by adoption of a process which is different from what is adopted in ordinary civil proceedings. Statement of objects and reasons. Several associations of women, other organizations and individuals have urged from time to time that the family court be set up for settlement of family disputes, where emphasis should be laid on the conciliation and achieving socially desirable results, and adherence to the rigid rules of procedure and evidence should be eliminated. The Law Commission in its 59th report 1974 had also stressed that in a dealing with disputes concerning the family, the court ought to be adopt an approach radically different from the adopted in the ordinary civil proceedings, and that it should make reasonably efforts at settlement before the commencement of the trial. The Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceedings relating to matters concerning the family. However, not much use has been made by the courts in adopting such conciliatory procedure, and the courts continue to deal with the family disputes in the same manner as other civil matters, and the same adversely approach prevails. The need was therefore felt in the public interest to establish family court for speedy settlement of family disputes. Section 13, 14 and 15 of the Act spell out a special procedure. The other provisions of the Act, Section 4, Clause 4, would indicate that a major objective behind the enactment of the Act is to have specialized body to preserve and save the institution of marriage. In the present case, there is no family dispute between the parties and the defendants. The dispute arose after the demise of Gunshalin, to whom both the plaintiff and defendant claimed to be married. The other plaintiffs and defendant too or children claimed to be born out of the respective marriages. The above would indicate that the dispute between the parties is purely a civil dispute and has no bearing on any dispute within the family, which needs to be resolved by a special procedure has provided under the Act. No issue with regard to the institution of marriage and the need to preserve the same also arises in the present case. That apart, the dispute between the parties can only be resolved on the basis of the evidence to be tendered by the parties. Admissibility of...
Is there any other judgment of the Supreme Court which has considered Section 7? Because Section 7 has not been considered here.
Adರಲ್ಲಿ consider ಮಾಡಿಲ್ಲ.
Copies ಕೊಡಿ sir. Copies of cloud.
Earlier, this judgment is also not considered in the subsequent judgment. Yes, ಇದರಲ್ಲಿ para mallots, all the provisions were considered, then mallots para 7 ಅಲ್ಲಿ that has been considered.
Yes.
7 and 8. Under section 7, 1 explanation B, a suit or a proceeding for a declaration as to the validity of both marriage and matrimonial status of a person is within the exclusive jurisdiction of the family court. Since under section 8, all those jurisdictions covered under section 8 are excluded from the purview of the jurisdiction of civil courts. In case there is a dispute on matrimonial status of any person, a declaration in that regard has to be sought only before the family court. It makes no difference as to the whether it is an affirmative relief or negative relief. What is important is the declaration regarding the matrimonial status. Section 20 also endorses the view which we have taken since the family courts in 1984 has an overriding effect on other laws.
Yes.
Therefore, in view of
ಇದರಲ್ಲಿ what were the facts?
mallots ಅಲ್ಲಿ
Facts are not similar.
first para ಇದೆ. The appellant instituted a civil suit before the family court, Ambikapur, Surgawa, Chhattisgarh, seeking a declaration to the effect that the respondent is not his legally married wife. By judgment dated, the civil court was decreed declaring that the respondent was not appellant's legally married wife. The respondent being aggrieved moved the High Court so and so. The High Court, as per the impugned order, allowed the appeal, holding that the family court lacked the jurisdiction to deal with the matter. According to the High Court, a negative declaration was ousted the jurisdiction of the family court. And then the provisions of section 7 and other things were considered.
Yes. So this was not
considered, brought to the notice.
Considered in this
Was also considered.
ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಬಲರಾಮ್
ಹೌದು
ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲಲ್ಲ.
ಆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ.
In Kasturi's case, because
ಕಸ್ತೂರಿ ಕೇಸ್
in Balram Yadav was
Balram
decided
Yadav was not considered in
year 2016.
ಹೌದು.
They have considered the provision of section 7. And they have held. It doesn't matter whether you are asking for a positive relief or a negative relief. And what was the relief sought there? Declare that the respondent is not the legally wedded wife of so and so. ಅದನ್ನ ಪಾಸಿಟಿವ್ ಆಗಾದ್ರೂ ಕೇಳಬಹುದು, ನೆಗೆಟಿವ್ ಆಗಾದ್ರೂ ಕೇಳಬಹುದು. Declare that I am the legally wedded wife of so and so.
Is quite different from declaring that.
But Supreme Court has held it doesn't matter whether it's a positive relief or a negative relief. But nevertheless, it is a declaration sought in respect of the marital status, which is clearly in terms of the provisions of section 7. In fact, it goes on to say the jurisdiction of the civil court is ousted.
Jurisdiction of the civil court in certain
Ousted
matters.
ಅಂತ ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ.
In certain matters ಅಷ್ಟೇ.
ಅದೇ
where the status of the family is at stake. But where the status of the family relatable to a property appatandra, civil court gets jurisdiction.
ಅದೇ no here
ಇಲ್ಲಿ only status they held it up.
correct.
When the status is relatable to a succession of a property, which the plaintiff claims in this case.
ಎಲ್ಲಿ
ನಾನು ರಿಲೀಫೇ ಇಲ್ಲ ಅದು.
ಇಲ್ಲ ರಿಲೀಫ್ ಇಲ್ಲ, but their pleading is that way. My lord, pleading
ಏನಾರು ಇರ್ಬೋದು. We are not
ಅಲ್ಲಲ್ಲ.
concerned about that.
Oh, so what happens when
ಏನಾರು ಇಟ್ಕೊಳ್ಳಿ.
what
The relief sought is declare
that she is the wife,
I am the legally wedded wife of
Wife.
so and so.
right, my lord? Now what happens? We'll have to invoke section 34 of the Specific Relief Act. Section 34 of the Specific Relief Act. Because every relief that is sought for, that has to have an incidental relief along with that. Without claiming that, no suit would be maintainable. That is the clear case under section 34. Idhanalli, they have asked for only declare that she is the legally wedded wife. Now, the fact of she being the legally wedded wife and me being the legally wedded is not at all in dispute.
Why?
I have already stated in my written statement
ಏನಂತ?
that both are legally wedded wives.
ಹೆಂಗಾಗುತ್ತೆ?
Before 1956 ಆದ್ರೆ ಆಗಿರುತ್ತೆ. ಅದಕ್ಕೆ the husband himself has executed registered partition deed, giving one set of properties to her and one set of properties to me. Registered partition deed. Now they have sold their properties. Now they have the similar name of Narsana in both the branches. One the Narsana is they belong to. Another Narsana is I belong to. The second Narsana which I belong to, they want to take over that.
These are all matters.
That is to be decided.
Matters then can be decided.
That is why my lord.
All that we are concerned.
Sir, that is why my lord, the Supreme Court very consciously asked the parties to go and approach the civil court because it is relatable dispute to a property.
What should happen to section 7 then?
But nonetheless, it is the order of the Supreme Court. Go and decide it there on the road. Civil court, when it is relatable to a property, you go to civil court because when the dispute is not actually with regard to relationship. However, let the court decide who is the first wife or who is the second wife. Adike, if your lordship is please to turn to page number 21 and 22 of the appeal memo.
One ನಿಮಿಷ. Let us see section 7 again.
ಇಲ್ಲ ಇದ್ರೊಳಗೆ ಕೇಳಲಿಕ್ಕೆ ಅವರು they don't want to ask a relatable dispute. ಕೇಳಿದ್ರೆ we could have understood. Yes, ಅವ್ರು correct ಇದ್ರಪ್ಪ, right ಅಪ್ಪ, let the court decide who is the first wife and then who succeeds to that property ಅಂತ. ಅದು ಕೇಳಕ್ಕೆ ಇಲ್ಲ, only first wife I want to be declared as a wife and that they want to make it use it in the other proceedings.
Yes.
So that is not permissible ಅಂತ Supreme Court ಏನ್ ಮಾಡ್ತು, the parties controversy can be decided by civil court only.
ಒಂದೆಲ್ಲ ಡಿಸ್ಕಷನ್ ಇಲ್ಲ ಅದರಲ್ಲಿ. You cannot read so many other things into it. Additionally, these type of discussion is not there. What you are trying to make out.
Civil court ಅಂತ ಹೇಳಿ
ಇಲ್ಲ. We'll come to it.
It is.
First, let us see.
It is reproduced. It is reproduced. It is reproduced in page number 22.
Yes, yes.
22.
Yes,
Section 7.
please read section 7.
Subject to the other provisions of this act, a family court shall have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time being in force in respect of suits and proceedings of the nature referred to in explanation, and B, be deemed for the purpose of exercising such jurisdiction under such law to be district court, or as the case may be, such subordinate civil court for the area to which the jurisdiction of the family court extends. The suits and proceedings referred to in this subsection are suits and proceedings of the following nature, namely, a suit or proceeding between the parties to a marriage for a decree of nullity of marriage, declaring the marriage to be null and void, or as the case may be annulling the marriage, or restitution of conjugal rights, or judicial separation, or dissolution of marriage. A suit or proceeding for a declaration as to the validity of a marriage, or as to the matrimonial status of any person. A suit or proceeding between the parties to a marriage with respect to the property of the parties or of either of them. This is also not covered. A suit or proceeding for an order or injunction in circumstances arising out of a marital relationship. A suit or proceeding for a declaration as to the legitimacy of any person. A suit or proceeding for maintenance. A suit or proceeding in relation to guardianship of the person or the custody or to access to any minor. Subject to the other provisions of this act, a family court shall also have and exercise the jurisdiction exercisable by the magistrate of the first class under chapter 9.
Now you
relating
please come to section 8.
Exclusion of jurisdiction and pending proceedings where a family court has been established for any area. No district court or any subordinate civil court referred to in subsection 1 of section 7 shall in relation to such area have and exercise any jurisdiction in respect of any suit or proceeding of the nature referred to in explanation to that subsection. Relevant, next, no magistrate shall, adu baralla. Every suit or proceeding, next is, adu baralla. Section 20 vacant.
So this is why the Supreme Court has said it is an exclusive jurisdiction of the family court only. No civil court can entertain such a, that is what the Supreme
And
Court has said.
section 20 overrides all the other acts.
See, both these provisions have not been looked into in Kasturi's case.
There are other judgments also, my lord, but civil court
Because a suit or proceedings between the parties to a marriage with respect to the property of the parties
yes,
is also there.
ಅದು ಕೇಳಬೇಕಾಗಿತ್ತು. Without that, the suit would not be maintainable. That is why the trial court dismisses. Trial court ಅದಕ್ಕೆ dismiss ಮಾಡಿದೆ.
Consider. But placing reliance on Kasturi.
Kasturi is one part.
Yes, yes.
In the final concluding area itself, may I invite the attention of your lordship to page number 26 of the appeal memo.
ಆಮೇಲೆ ಬೇರೆ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ಸ್
ಇದು ಬಿಟ್ರೆ
other judgments that have been considered?
I have verified.
ಅಲ್ಲ, there are so many other judgments that are considered here. Joseph Burgess, in the impugned order,
Three
Joseph
judgments are
Burgess.
considered.
Karnataka na?
Karnataka. Family, Supreme Court concerned, there are these two
Balram Yadav.
Balram Yadav, now what?
ಅದೇ. ಇಲ್ಲಿ where is R Kasturi?
R Kasturi.
That's referred in page number
21. 21 ಅಲ್ಲ.
21. Running page number 20.
Page number 25 minutes. Para 18. It is held by the Honorable Apex Court in its judgment reported 2018 Part 5 SCC. R Kasturi and others versus M Kasturi and others.
All right, we shall read Kasturi once again. You have read out from paragraph number 2.
Two in the ಓದಿ.
Huh?
ಹೌದು. Para two in the ಓದಿ.
Lieu, para one ಹಿಡಿದೆ ಅದು ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ.
Yes, yes.
Lieu granted, the appellant's plaintiff had instituted a civil suit OS number so in the city civil court, Madras.
Correct. It was filed before the civil court.
City civil.
Correct.
And the court holds that that court has jurisdiction.
Now, please see the prayer. In paragraph number, ಅದೇ judgment ಅಲ್ಲಿ. Paragraph number 1 ಅಲ್ಲಿ, what was the prayer?
Declaring that the first plaintiff is the legally
Wedded wife of Gulshan,
Second pertains to the children.
legitimacy of the children.
Children.
Third pertains to being the legal heirs to succeed
wife, children and mother.
as the legal heirs.
ಅಷ್ಟೇ. There was nothing relating to property.
Legal heirs for the sake of property only. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಲಾಸ್ಟ್ ನಲ್ಲಿ ಹೇಳ್ತಾರೆ my lord.
Prayer C would be the one of the consequential relief because the once the prayer one is answered in the affirmative, then the prayer C would automatically they become legal heirs.
ಅಷ್ಟೇ.
ಹೌದು. ಅದಕ್ಕೆ ಅದು
No. We are only trying to analyze whether there was a separate prayer made in respect of
properties
and whether the Supreme Court has considered that one in the light of the provisions in section 7.
7B.
We don't find
There
that
is a-
section 7 has been noticed.
Section 7B, 8 and 20. Three provisions are not considered.
No provision of the family court has been noticed.
Considered. And this specifically refers to section 7D
Yes.
under the explanation.
On the other hand, in Balram,
It has been considered.
all the provisions of section 7 and 8 have been considered.
And
May I just, may I ask?
Yes.
Here, if your lordship, if I may directly invite the attention of your lordship to page.
No. In fact, even declaration in respect of property also is permissible.
Yes, they have to seek that.
There is no compulsion, sir.
Compulsion ಇದೆ ಮೇಲೆ.
You may argue that one. For the time being, we are only concerned with the jurisdiction.
ಅದೇ, because of that
All your argument regarding whether such a suit, that question you will raise even in a civil court. So therefore, you reserve all that for arguing on the merits of the matter. Now we are only concerned with the jurisdiction of the family court.
The family court will not have a jurisdiction if.
Sir, please see the provision, sir.
Provision has seen, my lord, it cannot be read in isolation ಅಂತ ಹೇಳೋದು ನಾನು.
That
It
is
will
an
have to be-
argument
it have-
that you can make on the merits of the matter. We are now concerned with the jurisdiction of the family court, having regard to the provisions. That is all. ನೀವು argue ಮಾಡಿ. ಮಾಡಿ.
If it is barred by law, this is only
It's-
jurisdiction, territorial jurisdiction.
Territorial ಅಲ್ಲ.
We are concerned only with the jurisdiction of the family court. ಅಷ್ಟೇ.
May I just answer that in one simple? Why did this necessity to file the suit arise?
Sir, we are
ಅಲ್ಲಲ್ಲ,
not
we'll have to go into.
in regard to the prayer made in the
No, my lord, it is on the basis of the Supreme Court directions. Supreme Court directions.
is filed
ಅದಕ್ಕೆ
based on
ನಾನು
the
ಹೇಳೋದು
Supreme
ಅಷ್ಟೇ.
Court. ಅದು ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ? Where is that?
I will give, I am giving, that is observed and I am providing that copy. ಅದಿಲ್ಲ.
What is the background? How is it that the matter had gone before the Supreme Court?
My lords, in the year 2010,
Ah.
one G. Narsa Reddy dies, my lords.
Hmm.
He is the husband of the defendant number 1. The name of the present plaintiff is G. Narsanna. He is a government employee.
Huh?
He is a government employee. He died, not thereafter, after the death of G. Narsa Reddy, the similar names were there. The defendant's husband's name and the plaintiff's name, G. Narsanna and Narsa Reddy. What they claiming is, my lords, she is legally wedded wife of G. Narsanna and they got the mutation. Narsanna Satru or Narsannan property Namdanta. He is a close relative. He knows, my lords, all these transactions. Therefore, we challenge the mutation proceedings before the assistant commissioner. Since my husband is G. Narsanna,
So there are two different persons according to you.
according to them, according to me,
Ah,
there are two persons. I am the legally wedded wife of G. Narsanna.
correct.
Therefore, I have to be declared as a wife of G. Narsanna.
And she,
She G. Narsa Reddy.
Ade.
Narsa Reddy alias Narsanna anta what
Correct,
they are
correct.
claiming.
Gottaಯ್ತು. So
ಅದಕ್ಕೆ-
there are two different persons.
Two different
according to you.
persons. That is what our claim
Yes.
is. And the assistant commissioner
Ah.
allowed the mutation proceedings and directed to restore the legal heirs names
Ah,
of G. Narsanna.
Ah.
Then it went to the deputy commissioner. Thereafter, this approach to this honorable court. This honorable court has remitted to the assistant commissioner for re-examination. That order was came to be challenged before the SLP, in the SLP.
Ah.
In the SLP proceedings, the court referred that since the dispute is pertaining to the
both burn. Let us read, let us not simply go by,
para 7,
but let us read the.
para 7 in start.
Huh?
No,
Para
para
7.
4 in starter.
Para
4 in start ಆಗುತ್ತೆ, 7 in the actually relevant.
ಅಲ್ಲ, paragraph 5 ಇಂದ ಓದಿ.
The question that arises for consideration in the instant appeal is who out of the appellant number 1 and respond number 1 is the legally wedded wife of late Narsanna alias Narsa Reddy. It appears that after the death of Narsanna alias Narsa Reddy, the land measuring 8 acre 24 gunta situated at Taluk and district of Raichur was mutated in favor of the appellant number 1. The said entry came to be challenged by the respond number 1 after 21 years. The revenue authorities entertained the claim of the respond number 1 and set aside the mutation dated 5/2/2001.
After 21 years.
ಹೌದು.
It was in my name,
that-
they
that is,
challenged it after 21 years.
In favor of the appellant
Ah.
number 1. Feeling aggrieved, the appellants challenged the order of revenue authorities before the deputy commissioner who, in purported exercise of his power under section 136(3) of the Karnataka Land Revenue Act, allowed the revision petition and reversed the entry which was earlier made in favor of the respond number 1. The aforesaid order of the deputy commissioner was assailed by the respond number 1 before the High Court and wide impugned order and the order dated 11/8/2022. The High Court has set aside the order and remanded the case to the revenue authorities to give an opportunity to the respond number 1 to explain the delay of 21 years in seeking correction in the revenue records. We have heard learned counsel for the parties at a considerable length and are of the considered view that the recourse adopted by the parties in approaching the revenue authorities is an exercise in futility, as neither the deputy commissioner nor any other revenue authority is competent to determine the status of the appellant number 1 or respond number 1 as the legally wedded wife of late Narsanna alias Narsa Reddy. Such a controversy can be decided by the civil court only. Faced with this, the learned counsel appearing on behalf of the respond number 1 submits that the said respondent will file a civil suit in this regard immediately. In this view of the matter, we allow the instant appeal in part and dispose of the matter in the following terms. Respond number 1, if so advised, may file a civil suit within 1 month. The learned civil court, having regard to the age of the respond number 1 and also keeping in view the nature of the list, shall make an endeavor to decide the civil suit as early as possible. Till the disposal of the civil suit, the appellant number 1 shall neither relate nor create any encumbrance upon the suit property. The entry in the revenue records shall be subject to outcome of the civil court matter.
Correct. So all that is now required is a declaration.
Declaration.
ಅಷ್ಟೇ. Who is the legally wedded wife of
the Narsanna or alias Narsa. If anyone, the court declares.
I agree, but where that should be ante, where that should be, because who has to succeed?
7B is clear.
Para number 6 nalli, the court has made it very clear. It appears that after the death of Narsanna, the land measuring 8 acre 24 gunta situated at so was succeeded by whom comes the question. So for that matter, the court directed, because in a family court, the inquiry is already always summary. In a civil court, the inquiry is full based on Indian Evidence Act. So for that reason, the court directed the parties to approach the civil court. Family court is not a civil court, definitely, for that matter. One point. Now, the second point which the court also took into consideration was in para number 19 or at page number 26, my lord.
Yes.
Around 12 lines from the bottom, therefore in start ಆಗುತ್ತೆ ನೋಡಿ madam. Therefore ಅಂತ start ಆಗುತ್ತೆ. Therefore, principally the dispute is among the plaintiff and demandant, who is the wife of late Narsanna, to whom the land survey number 184, according to the pleadings, extent of belong to, and who have succeeded to the settled land after the death of Sarvan. Therefore, the dispute involved in this suit is not so simple as submitted by the learned counsel to the plaintiff to claim relief of declaration with the plaintiff with late Narsanna son of, without claiming necessary and consequential reliefs in respect of land in So when the Supreme Court itself has stated that you go to civil court, then he should have filed a civil suit before the civil court. And there also section 34 comes into play here of Specific Relief Act, which reads that there must be a discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Next. Provided that no court shall make any such declaration where the plaintiff being able to seek for further relief, more relief than a mere declaration of title omits to do so. So here, he has sought for only one relief, that I may be declared as the wife of so and so. He had to seek a consequential relief with that he is being the wife or being the husband, being the wife of so and so person, I would be entitled to succeed to this, because the dispute was essentially of the property that went up to the Supreme Court. Who should succeed it, that property at Bandaga? First decide who shall be this thing, and then that he has to seek for that relief. So that has not been sought for here. So for that reason, the court also observes that requires complete recording of evidence. So for that reason, this court would not have jurisdiction.
Everything will tilt on the question as to who is the legally wedded wife of so and so.
That we have admitted.
Is made.
Allah admit.
Everything else follows.
Allah, we have already admitted.
They did not specifically ask for so many other.
How to ask, mother?
Not necessary, sir. See, once the Family Courts Act has come into force.
Yes, family.
And the declaration regarding the legal status, including rights over the property, both find place in Section 7.
Section 7, there is a
Section 8 debars the jurisdiction of a civil court insofar as the declaration of the
status of the party
status is concerned. So therefore, even if there is a direction, it has to be read having regard to Section 8 of the Family Courts Act.
But
when a person is debarred from seeking such a relief before the civil court, we can only read the directions of the Supreme Court as a direction issued in the normal course. And depending on the special provision found in the Family Courts Act, it has to be read as family court only. Supreme Court has not taken note of all these provisions, sir. When such a direction was given, it did not consider whether such a relief could be asked before the civil court, having regard to the bar created in section 8.
Illa, with regards to that, with regards to bar, that has not been considered by the
But
Supreme Court.
That is
But
why.
it has consciously given that finding that it will. you
That
go
is
to
why,
civil court.
sir. That is why we are saying, in spite of that, they had to go before the family court because of this. They cannot go to the civil court.
But when the court itself states that because it requires a complete evidence, and that is the problem here now.
Even by consent of party, jurisdiction cannot be vested.
No, it can be, it cannot be vested,
No
but by the
court-
directions of the court,
no-
it can be changed.
ಅದನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರೆ it was a different thing.
ಅದಕ್ಕೆ
ಏನು
ಪ್ರಾಪರ್ಟಿ
ಮಾಡಿಲ್ಲ.
ಪ್ರಾಪರ್ಟಿ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ.
See, Supreme Court was not apprised of this problem. It did not consider all that. A general direction was given. Go for the civil court, get a declaration on. That cannot be read in such a manner that Supreme Court has consciously said, no, go to civil court only. Even if there is a provision for you to go before the family court. In fact, there is a compulsion.
There is a compulsion under section 10 when it is an original thing.
Nothing has been
Here we
considered.
are going on the direction of the the Supreme Court.
Correct.
That is the problem, my lord. Here parties are proceeding on the direction of the Supreme Court and not on the jurisdiction that the family court has. When the Supreme Court has altered the jurisdiction, I don't think so he would have a jurisdiction on. Supreme Court itself consciously has taken note of the fact that there is a dispute with regard to the property. That property issue will have to be settled by deciding who was the actually successor.
Then we will do one thing. We will narrate all these things and ask you parties to go before the Supreme Court only. Go get a clarification. In the light of the bar under section 8, they cannot file a suit before the civil court. So go get a clarification in the Supreme Court.
I will get instructions on that. Tomorrow I'll get the instructions. Tomorrow I'll tell the instructions otherwise.
Alala, there is no other alternative for us. If you insist, no, in terms of the directions of the Supreme Court, they had to go only before the civil court. We will ask you to get a.
Or else let the honorable court direct them to include the property declaration with respect to property.
Sir, we cannot do all that. It is the right of the party.
Party
to
to-
approach
He is the author of the, he is the author. of
decide
the-
what relief should be asked, what not to be asked.
That is
Why
the,
should we compel them? Not necessary.
tomorrow.
In section 10(3) also modes provides, the family court modes can lay down his own procedure if there are disputed
Correct.
facts.
That is there.
See, not that the family courts are precluded from calling for evidence. Not so.
Summary ಅಂತಿದೆ.
ಇರ್ಬೋದು.
Summary makes a difference, my lord. When there is a summary inquiry provided, that makes a difference.
Evidence cannot be called for.
Civil court, section
ಹೌದು,
10.
section 7 ಅಲ್ಲಿ
As a
Section-
civil court, family court can decide.
section 10(3) is very clear, Manoj.
Even apart from that.
The inquiry before a family court,
Sir, without calling for evidence, it is not possible, sir. Even in a regular family matter where divorce is sought,
Section 10 is-
And there will be a
court
dispute.
calls for evidence.
CPC is
Otherwise, it would be impossible to not adjudicate the disputes. Because every family court will deal with the disputed facts.
Section 50. The
It
family
it
court
can,
They can lay down their own procedure.
ask jurisdiction.
ಹೌದು.
There is no summary.
No, the entire reasoning behind that is there should be a quick disposal of cases.
yes,
The procedure.
that's the object of the family court.
ಇನ್ನೇನಿದೆ ನೀವು ನಿಮ್ಮ ಪಾರ್ಟಿನ ಕೇಳೋದೇನಿದೆ? We will have to pass orders.
I'll find out if there's some other rulings at the Patanda. As your lordship said, that the ruling that I submitted did not contain the earlier set.
Correct.
I'll find out if there is any. But tomorrow I'll submit. If it can make a difference to this.
We have heard. learned counsels on both the sides extensively. Full stop. Nevertheless, at the request of learned counsel for the respondent, release this matter tomorrow.
Let's next matter, my lord.
V. Srinivas.
My lord, I appear for appellant in this case, my lord. My lord, we have deposited the amount as per the order. My lord, am I audible, my lord? Because the court audio, my lord, I am unable to see the court and
Huh?
my lord, I am unable to see the court, my lord. Therefore, I am making a submission whether I am audible or not, my lord.
Yes, you are audible, but we are also able to see you.
Yes, my lord. My lord, I have deposited the amount on 21/8/2024 before the executing court, my lord, in execution 10 of 2024, my lord, under a DD bearing number 68476, my lord, before the drawn on Bank of India. I have deposited before the trial court, my lord, before the executing court. In compliance of the order of this honorable court, my lord, I have deposited before the executing court, my lord.
Learned counsel for the appellant submits that the appellant has deposited 30% of the decretal amount
Yes, my lord, that is 6,80,700 rupees.
along with accrued interest before the trial court. Yavaga, when did you deposit? Executing.
My lord, on 24/8/2024, my lord.
2024. Why have you not furnished the acknowledgement or the copy of the memo
Yes, my
or
lord,
whatever?
I'll furnish it in the next date of hearing, my lord. I furnish it. But I was under the impression that I should deposit before the trial court. Therefore, I have not furnished, my lord. I'll furnish it, my lord. I'll furnish a copy of the DD, my lord. Delay of 9 days in filing the appeal, my lord.
In your wakalat,
Yes, my lord.
why have you not shown the name of the learned counsel, local learned counsel?
My lord, I have asked him to sign, my lord. I asked one of my colleague Anand Ture to sign the wakalat. And, I have sent only the files to him, my lord. I think by mistake he might have mistaken, my lord. My address for service I have put, and I have also asked him to put his signature and sign also. Anand Ture is the local advocate, my lord, along with me, who is appearing there.
Yes. Next para, learned counsel is required to furnish a copy of the acknowledgement or any other information to show that the amount has been deposited before the executing court. Within a week from today.
Yes, my lord. My lord, 9-day delay may be condoned. It may be posted for admission in the meantime.
Delay may not be condoned because Limitation Act does not apply to commercial appeals.
There cannot delay cannot
Delay
be condoned.
cannot be condoned, Your Lordship.
And we'll have to consider.
I'll furnish citations in that regard, my lord. Yes, my lord.
Yes, all right.
Much obliged.
C number 30. Sudarshan.
Lord, this is the writ appeal filed against me, Lord. The interim order passed on 2/9/2024. In the petition, Lord, 202285. Lord, interim order at Lord, kindly see page number. Lord, 13.
Interim order.
Interim order. It is a matter, my lord, pertaining to, my lord, TMC elections. Wherein, my lord, petitions have been filed, my lord, challenging the, my lord, notification dated 5/8/2024 issued by the state government. That is based on, my lord, reservation. My lord, here, what had happened, my lord, one of the, my lord, aggrieved, my lord, member of the TMC of Kembawi, Lord, files a writ petition. Lord, when Lord, calendar of events were Lord already Lord announced and Lord scheduled, and Lord the writ petition was Lord taken on 2nd September. Election was very next date, Lord, 3rd September. And however, Lord, the matter was Lord taken up, and this is a stay, Lord, granted. Kindly come to Lord page 14. Operative portion, that is order. Lord, learned AG is directed to accept so and so, my lord. Para 2, the notification bearing so and so dated 5/8/2024 at Annexure C in respect of serial number 63 is stayed till the next date of hearing. And my lord, this is an observation and order, my lord, directing, my lord, my lord, serial number 63 is, my lord, pertaining to, my lord, the appellant, my lord, respondent herein, who, my lord, after coming to know about this, my lord, interim order, my lord, filed a impleading application in this, my lord, very, pardon,
Annexure C.
Annexure C, my lord, of the writ petition.
As per the directions of Honorable Supreme Court, the request of the government, National Informatics Center has developed a software and submitted reservation chart for the office of President and Vice President in urban local bodies for the 10th term. Said reservation chart was filed before the Honorable Supreme Court on so and so through an affidavit by the state government. Now the government decided to allot the same reservation as submitted to Honorable Supreme Court as per section 42 of the Karnataka Municipalities Act. This has been stayed.
This has been stayed insofar as
Serial
item number 63, my lord. Kindly come to, my lord, page 39.
Kembavi.
Kembavi, please. BCI and SCW, President and Vice President. And a similar set of facts, my lord, I, my lord, in turn, my lord, filed a impleading application immediately after coming to know about this. And my lord, we came on record and filed, my lord, statement of objections also, my lord. Kindly come to, my lord, page 215. My lord, my statement of objection.
No, did you not seek for vacating the order?
We filed, my lord, vacating, my lord, I also. It is also still pending consideration, my lord.
It is not yet
Still
considered.
not yet been considered, my lord. Now, my lord, what had happened, my lord, the Harvard bench, my lord, a similar set of matters. My lord, learned single judge, my lord, heard the matters and reserved the, my lord, writ petition orders. And presently, my lord, we are, my lord, this order, my lord, hanging on our, my lord, head, this like sword, my lord, and we are unable to, my lord, work out whatever the remedy. My lord, because of that, my lord, earlier, my lord, last occasion, my lord, the single judge, learned single judge has, my lord, adjourned the matter by 12th December. And presently, my lord, we are pressing for this, my lord. As of now, my lord, calendar of events when, my lord, invoked. And, my lord, we, my lord, pressing for, my lord, can't be interfered. And that is how, my lord, my lord, relied on my lord, judgments of, my lord, 1952, as my lord knows.
It is only
That is the only, my lord.
announcement of the reservation. Ashte.
Ashte, Swami.
Alva.
House.
Elections were not scheduled.
Scheduled, my lord.
Calendar of events were announced.
My lord, calendar of events announced at page number, kindly come to, my lord, 329. (329), my lord. It is, my lord, calendar of events, my lord, dated 26/8/2024, issued by the Tahsildar, my lord, Shorapur. My lord, wherein I may be, my lord, I come to, my lord, second para. ಅದರಂತೆ ಕೆಂಬಾವಿ ಪುರಸಭೆಯ 10ನೇ ಅವಧಿಗೆ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಗಳಿಗೆ ನಾಮಪತ್ರಗಳನ್ನು ಅಭ್ಯರ್ಥಿ ಅಥವಾ ಅವನ ಸೂಚಕನು ಅಥವಾ ಅನುಮೋದಿಸುವವನು ದಿನಾಂಕ 3/9/24 ಮಂಗಳವಾರದಂದು ಬೆಳಗ್ಗೆ 10 ಗಂಟೆಗೆ ಮೀರದಂತೆ ಕೆಂಬಾವಿ ಪುರಸಭೆ ಕಾರ್ಯಾಲಯ ಕೆಂಬಾವಿಯಲ್ಲಿ ತಲುಪಿಸಬಹುದೆಂದು, ನಾಮಪತ್ರಗಳನ್ನು ಇದೇ ಸ್ಥಳದಲ್ಲಿ ದಿನಾಂಕ 3/9/2024 ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆ ವೇಳೆಯಲ್ಲಿ ಪರಿಶೀಲನೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುವುದೆಂದು, ಅಭ್ಯರ್ಥಿ ಅಥವಾ ಸೂಚಕ ಅಥವಾ ಅನುಮೋದಕನ ಉಮೇದುವಾರಿಕೆಯನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳುವ ನೋಟಿಸ್ ಅನ್ನು ದಿನಾಂಕ 3/9 ನಿಗದಿಪಡಿಸಿದ ಅವಧಿಯಲ್ಲಿ ಸಲ್ಲಿಸಬಹುದೆಂದು ಮತ್ತು ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧೆ ಇರುವ ಸಂದರ್ಭದಲ್ಲಿ ಚುನಾವಣೆಯನ್ನು ಅದೇ ದಿನ ನಡೆಸಲಾಗುವುದೆಂದು ನೋಟಿಸ್ಗಳನ್ನು ಎಲ್ಲಾ ಸದಸ್ಯರುಗಳಿಗೆ ನೋಟಿಸು ಜಾರಿಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಮೀಸಲಾತಿ ಹಿಂದುಳಿದ ವರ್ಗ BCA ಹಾಗೂ ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನ ಮೀಸಲಾತಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮಹಿಳೆ ಇರುತ್ತದೆ. So, my lord, this is the content, my lord, where, my lord, we focus on. By reading of this, my lord, calendar of events will be announced by the my lord returning officer.
So ಮಿಕ್ಕಿದ್ದ ಮುನ್ಸಿಪಾಲಿಟೀಸ್ಗೆ ಎಲೆಕ್ಷನ್ಸ್ were held.
ಬೇರೆ ಎಲೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಆಗಿ ಹೋಗಿದೆ ಸರ್. ಇದು ನಮ್ದ್ರಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ my lord we were not party. September ಅಲ್ಲಿ. Because of this, my lord, my lord, our constituency elections been my lord stalled. And my lord, there is no progress in the matter. Lord, my lord's judgment is also there in similar situation, my lord. Apart
How
from
many judgments?
House, several
How many
judgments.
judgments? We have said the
House. Lord. Sir.
But when was the?
Please.
Next year, see. What is the date?
5/8/2024, notification date.
Five eight.
House.
This order was passed on?
My lord, 2/9, my lord.
2/9.
Please. And my lord calendar of events was published on 26/8. That is at my lord 329 page number. My lord, in this judgment, may draw my lordship attention to para 8, 9, and 10, my lord, regarding my lord judgments discussed by the my lord the councils on record. Thereafter, my lords come to the conclusion, para 11, kindly see, my lord. The judgments of the Honorable Supreme Court cited by the learned counsels for the appellant as well as senior counsel for the returning officer would aptly summarize the essence of such judgments, which clearly hold that legality of the process of election and declaration of results can be gone into only by an election tribunal constituted for that purpose. Fourth respondent herein had filed writ petition seeking direction that returning officer should prepare a list in conformity with list published by the registrar of KMC so and so. And returning officer should permit only such persons whose registration is in so and so. Lord, however, Lord, kindly see para 12 and 13. I'm sorry, para 12. It is continued at para, Lord, page number 21. Third line, my lord. Therefore, this court would not hesitate to hold that impugned orders passed by the learned single judge would go well beyond the scope of the writ petition. Insofar as judgment cited by the learned senior counsel for the contesting respondent, there can be no quarrel that this court is entitled to mold the relief having regard to the subsequent events.
Yeah, this is not the relevant judgment.
Please. My lord, kindly see.
No, we have considered.
Huh.
This is a notification of reservation.
Reservation. At the beginning stage.
So whether that can be questioned and whether that can be stayed, we have considered in other judgments.
Okay.
This is not pertaining to that.
Please. My lord, I relied on, my lord, kindly see, my lord, para. My lord, my statement of objection is at my lord, page number 215 of the writ appeal. Para 8 and para 9, my lord. That is page 220. But kindly come to page 10. I mean para 10. That in similar situation, Constitution Bench of the Honorable Supreme Court in reported judgments in so and so, that is a NP Pannuswamy versus returning officer, has clearly held that para 25, the conclusions which I have arrived at may be summed up briefly as follows. Para 1, I mean, it is sub para 1. having regard to the important functions which the legislatures have to perform in democratic countries. My Lord, this is how I would directly take to my lordship to my Lord the judgment where I am referring to. Kindly come to my Lord page 245. Para 25. May I please, my Lord? The conclusions which I have arrived at may be summed up briefly as follows.
ಯಾವ judgment?
My Lord, page 245.
ಪೊನ್ನು ಸ್ವಾಮಿನ?
Ponnu Swami.
Huh? See, Ponnu Swami is, no doubt, the law holds the field even now.
Yes.
That is, no courts should interfere in the process of election.
Yes.
That is why we are repeating,
Yes.
this is not a process of election. This is a notification issued for reservation of the categories.
Please.
You can't say this is a process of election.
No, mine is, my Lord, process of election.
ಯಾವುದು?
Mine, my Lord, as because by looking into, my Lord, page 329, where, my Lord, the returning officer already, my Lord, announced the my Lord, calendar of events.
That was announced on?
My Lord, 26/8.
Huh?
26/8.
26/8 is a notification of reservation, sir.
Illa, 26.
Calendar of events were announced after the interim orders are passed. This interim order is passed on 2nd of November.
Before one. I just draw my Lord's attention.
Yes.
My Lord, kindly see page 329.
ಇದನ್ನೇ ನಾವು ಹೇಳಿದ್ದು.
26/8. It is ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ವಿಷಯ ಕಕ್ಕೇರ ಪ್ಲೀಸ್ ಮತ್ತು ಕೆಂಬಾವಿ ಪುರಸಭೆಯ 10ನೇ ಅವಧಿಯ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಲಾಗಿರುವ ಬಗ್ಗೆ. ಪ್ಲೀಸ್. In reference to, my Lord, ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಯಾದಗಿರಿ ಅವರ ಆದೇಶದ ಸಂಖ್ಯೆ 14/8/2024. And the second para is exclusively, my Lord, dealing with my constituency.
Yes.
That is TMC Kemba, please. And, my Lord, the order passed, my Lord, interim order that is on 2/9. Subsequent to this, and very next day, my Lord, election was supposed to be held.
Now you read that.
Please, interim order, my Lord, kindly come to me.
Interim order ಅಲ್ಲ.
Judgment.
ಇವಾಗ ಓದ್ತಾ ಇದ್ರಲ್ಲ ನೀವು conclusion.
245.
245.
But para 25, the conclusions which I have arrived at may be summed up briefly as follows. One, having regard to the important functions which the legislatures have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as early as possible according to my time schedule, and all controversial matters and all disputes arising out of election should be postponed till after the elections are over, so that election proceedings may not be unduly retarded or protracted. Two, in conformity with this principle, scheme of the election law in this country as well as in England is that no significance should be attached to anything which does not affect the election. If any irregularities are committed while it is in progress and they belong to the category or class which, under the law by which elections are governed, would have the effect of vitiating the election and enable the person affected to call it in question, they should be brought up before a special tribunal by means of an election petition and not be made the subject of a dispute before any court while the election is in progress. This is one, my Lord. And the second judgment, my Lord, I referred, my Lord, at page number. Kindly come to, my Lord, 257.
We will have this matter on Monday.
Monday, my Lord.
We will issue notice.
Please.
You serve a copy.
I served a copy.
ಇವರೆಲ್ಲ ಅವರು ಗಲಾಟೆ ಮಾಡ್ತಾರಲ್ಲ ಬಂದು ಅವರು ಫಸ್ಟ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. We will hear them also.
Please.
They are not here today.
Yes, they are not here.
Learned government advocate takes notice for respond number 1.
1 and 3.
And 3. State Election Commission ಯಾರು?
Amrish Roja.
Learned Counsel Shri Amresh S. Roja.
Please.
Is requested to take notice for respond number 2. Issue notice to respond number 4.
5 may serve an advocate who appearing in, my Lord, writ petition. Mr. M. Nagra.
the appellant is permitted to take out hand summons to respond number 5. Full stop. In addition, the appellant is also permitted to serve a copy of the appeal memo along with annexures on learned counsel Sri
AM Nagaraj, ma'am.
A.M. Nagaral,
Please,
who appeared for the 5th respondent
please,
before the learned single judge.
please.
Learned counsel for the appellants shall serve copies of the appeal memo along with annexures on the learned government advocate and learned counsel for respondent number 2. Full stop. Release this matter on 2nd of December
Please. Obliged much.
for preliminary hearing,
House prelim,
for
House admission,
admission.
please.
CL number 33, Priti Patil Malpundi.
Yes, insurance company challenge liability matter, the 42 days terms of violation of condition of policy matter and the vehicle used for hire and rent purpose.
Insurance company.
Yes, madam, sir.
Ah,
Challenging liability matter in this.
execution petition file ಮಾಡಿ
Yes, file ಮಾಡಿ sir. Immediate EP ಬಂದ್ಬಿಡುತ್ತೆ sir, ಆಮೇಲೆ ಗೊತ್ತು.
to the respondents. Full stop. Next para. Senate counsel for the appellant submits that although there is a delay of 42 days in filing the appeal, nevertheless, the appellant nevertheless, since the claimants, respondent claimants have filed execution case to execute the impugned judgment and award, learned counsel prays for ad interim order of stay, subject to any condition that may be imposed. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned judgment and award in MBC number 46 of 2021 on the file of the second additional district and session judge and MACT at Raichur till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
Much of.
CL number 34, Bapugoda Siddhappa.
Seeking for enhancement of case of injury matter.
Huh?
Seeking for enhancement.
Enhancement.
Yes, my lord.
But in this case, my lord, I will accept my lord notice on behalf of respondent number 2. HDFC
Learned counsel Sri
Manjunath Mallaya Shetty.
Manjunath Mallaya Shetty
Please.
undertakes to appear for respondent number 2.
R1
Learned counsel, another,
R1 dispense.
for the appellant is directed to serve copy of the appeal memo along with annexures on the learned counsel for respondent number 2. Full stop. Next para. Learned counsel has filed a memo seeking dispensation of notice to respondent number 1 on the ground that respondent number 1 is the owner of the vehicle.
Yes.
And the liability has been fastened on respondent number 2.
Please. Lord, and also
At
kindly
the
refer
risk
to
of the appellant, notice to respondent number 1 is dispensed.
refer to local. Already we are negotiated.
752 days.
My lord, without interest, they'll make.
Next para. IA1 of 2024 is allowed while condoning delay of 752 days, on the condition that the appellant shall not be entitled for payment of interest during the delayed period.
Please.
Full stop. Next para. Matter stands referred to the ensuing Lok Adalat.
Please.
CL number 35, Bapugoda Siddhappa.
Okay, case for injury matter, seeking for enhancement matter. There is a private respondent. Seeking for enhancement matter, case for injury matter. There is a respondent number, private respondent matter, issue notice.
Insurance company illa
Yes.
issue notice to the respondents.
CL number 36, Sharan Basappa and Patil.
Appearing for appellant, my lord, this is an insurance appeal challenging liability, my lord, on the ground that they have not made the party before the tribunal, my lord, rider of the bike, my lord, and owner of the bike. And even below the trial court has considered, though they have not made party, 5% of the disability, sorry, my lord, 5% of the negligence has been fixed on the rider of the vehicle, owner of the rider of the bike.
50% deposit ಮಾಡಲೇಬೇಕು.
Please.
To deposit.
Yes.
ಸೇವ್ ಮಾಡ್ರು ಅವಾಗ್ಲೇ ಮಾಡಿದ್ವಲ್ಲ ಹಾ ಹ್ಮ್
Seal number 37, Santosh S. Gogi.
Appearing for complainant, your lordship. Your lordship, this is the complaint wherein accused number 1 and 2, your lordship. May I make a submission, your lordship?
yes
Here, the accused number 1 and 2, your lordship, files and suit seeking for partition and separate possession, your lordship, wherein the Honorable Trial Court was pleased to issue emergent notice and suit summons on defendants, your lordship. However, the accused number 3, who is an advocate, your lordship, has given a public notice with wrong information of judicial proceedings, your lordship, wherein he has mentioned that interim order has been granted and attachment order in respect of suit scheduled property is being issued, your lordship. The paper notice is at annexure D, page number 72, your lordship. Yes, your lordship. Annexure D, page 72.
72 is a copy of the order sheet. Annexure D na.
Yes, your lordship. Newspaper publication dated 10/2/2022. Annexure D.
This newspaper.
Yes, your lordship.
This is at page number 88.
My apologies, your lordship. It is on the left hand side.
Hand side up. Yeah, which page?
Your lordship, it is at the page in my petition, it is showing a 72, your lordship. My apologies. It is marked, your lordship, the relevant portion.
That is the newspaper publication.
Yes, your lordship, newspaper publication. Wherein the public notice has been issued, your lordship. If I may be permitted to read.
Who has given public notice?
This has given by the advocate, your lordship, that is accused number 3 hearing.
What do you mean? This is not an advertisement. It's a new newspaper report.
This is the public notice which has been given
What
in
do
the
you mean
newspaper.
public notice? When this cannot be construed as a public notice. It is a news published by the newspaper. How are you saying that the advocate has published this one?
The advocate has given this notice, your lordship, to publish in the newspaper.
Madam, if you are referring to a particular page in the newspaper, you please say which is that one.
Your lordship, it is. Wherein it is referred as public notice.
Yeah. Public notice.
Yes, your lordship.
Has filed OS number so and so, pending on file of so and so. for relief of partition and separate possession against
Yes,
K.
sir.
Yellaya and K. Vijay Kumar and others. And Honorable Court has granted ex parte injunction order in respect of suitable properties.
Yes, Your Lordship.
Ah,
Wherein the Honorable Court has issued only emergent notice.
hereby requested to not purchase or make any kind of deal with the above said property since the same is already under litigation and attached before the Honorable Court. Ah,
The Honorable Court have just issued emergent notice on that, Your Lordship.
hmm. What is the content of Courts Act? What is? Madam, you should have filed a criminal contempt. Civil contempt is not maintainable.
With the liberty, Your Lordship.
Please see the definition of the word criminal contempt.
Yes, Your Lordship.
Criminal contempt means publication of any matter or the doing of any other act whatsoever which scandalizes or tends to scandalize, prejudices or interference or tends to interfere with the due course of the judicial proceeding. So
Yes,
this
Your
would
Lordship.
amount to criminal contempt. And therefore civil contempt is not maintainable.
I may be permitted to file appropriate petition, Your Lordship.
For criminal contempt, the procedure itself is different. You will have to approach the Advocate General by filing an application, seeking his consent. It's a long process. Anyway, Burkle. Office and objection raise madilva? Madilla. This. Contempt petition has been filed under section 12 of the Contempt of Courts Act of 1971. With an allegation that the third respondent advocate who was appearing for the other respondents in a suit filed in OS number 32 of 2015 on the file of the second additional senior civil judge and civil judge, Kalaburagi, has caused a public notice in Kannada daily newspaper, Sanjay Vani, dated 10th of February 2022. that an interim injunction has been granted by the court. And therefore, no party should deal with the suit schedule properties in any manner whatsoever. Full stop. However, it is contended that no such interim injunction was granted by the trial court, and therefore the publication would amount to
Injunction attached. Court has attached.
Attachment order as well, Your Lord.
Attached before this honorable court. Expert in sorry.
to contempt, clearly prejudicing and interfering with the course of judicial proceedings. Full stop. Next para. However, this court finds that if such is the allegation, it would amount to criminal contempt in terms of the definition of the term criminal contempt as found in section 2 bracket C of the Contempt of Courts Act, 1971. We'll stop. A civil contempt, on the other hand, is defined as a willful disobedience of any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Stop. Next para. Learned counsel for the contempt complainant seeks leave of this court to withdraw the contempt petition and file a contempt petition in accordance with law. The criminal contempt petition in accordance with law. Full stop. Next para. Placing the submission of the learned counsel for complainant on record, the civil contempt petition is dismissed as withdrawn, while reserving liberty to the complainant to initiate, to proceed to take action in accordance with law.
Grateful, Your Lordship.
PL number 38, Avinash A. Uplankar.
Yes. His brother died, madam. Avinash Uplankar's brother died. We taken next.
Release this matter on
Next week.
huh?
Next week. Any day.
On 9th of December.
Admission matter, seal number 39, additional government advocate.
29, my lord, I place a week's time, my lord, to get the instruction, my lord, they are deposited or not. 50% amount, my lord, there is a direction.
A week's time is granted at the request of learned government advocate to file the acknowledgement for having deposited 50% of the award amount as directed by this court.
Please.
Seal number 40, AM Bhate.
Next to appear for appellate.
Appearing for respond number 4, my lords.
Yes.
There's a direction by this honorable court, my lord, to respondents 2 and 3. The accommodate, there is 4th respondent. The other vacancies available therein.
Clinical psychologist.
Yes. I was informed about, they have referred the matter to the governing council. They are likely to take steps in giving accommodation to the 4th respondent. That's what oral information I had.
For the
I am appearing for
institute,
Ravi Patil has.
4th respondent.
you are appearing for the institute.
No, my lord, 4th
Huh?
respondent.
Our 4th
Appearing
respondent.
for the institute.
Ravi
Ravi
Patil
Patil.
appears for
Ravi Patil.
institute.
Huh?
Ravi Patil appears for institute, my lord.
Ravi. Ravi B. Patil.
This honorable court has directed the respond number 2 and 3 last time.
Yes.
Lordship, kindly have it.
You not secured instruction.
Kindly model.
At the request of learned counsel for respond number
2 and 3.
2 and 3. Why he was here today, isn't it?
He's engaged in other court.
What?
We can pass over.
Sir,
then.
please, please.
Huh?
Please.
Pass over.
Seal number 41, Kaujalgi Chandrakant Lakshman. For
R1 is dispensation. Liability bids salary amount is issued. R1 dispensation, United Intentions R2. R2 is United Intentions.
Learned counsel Sri Manavendra Reddy is requested to take notice for
R2.
respond number 2. Learned counsel for the appellant is directed to serve copies of the appeal memo along with the annexures and learned counsel for respond number 2. Next para dispensation for respond number 1. Huh?
Yes.
Seal number 40.
Yeah, refer ಮಾಡಬಹುದೇನ್ರಿ?
Liability is 2025.
Seal number 42, Manvendra Reddy.
It's an appeal filed by insurance company challenging liability, my lord. I deposit 50%.
Stay ಮಾಡಿಲ್ವಾ?
Stay ಆಗಿಲ್ಲ, fresh matter.
Fresh matter. No delay.
No delay.
Application
because there is no delay. In time. Issue notice to the respondents. In the meanwhile, there shall be an ad interim order of stay of the impugned judgment and award in MBC number 1312 of 2022 on the file of the second additional senior civil judge and JMFC and additional MACT, Kalaburagi till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal.
For this court will.
Within a period of 6 weeks from today.
Big of matters, seal number 43, Mahantesh Patil.
In this matter, first it may be taken next week, my lords. And the senior counsel is Jayakumar S. Patil sir is engaged not by the client. And one more thing, my lords, which I want to brought. One judgment, my lords, wherein it is yesterday we received it copy. The Bangalore bench, my lords, section 14A of the CCR rules, wherein it provides for entrustment of the inquiry to the Lokaayukta for conducting disciplinary proceedings, my lords. That is held as unconstitutional and arbitrary. ಅದಕ್ಕೆ ಆ ಜಜ್ಮೆಂಟ್ ನಿನ್ನೆ ರಾತ್ರಿ ನಮ್ಗೆ ಡೌನ್ಲೋಡ್ ಆಯ್ತು. ಅದು ಇಷ್ಟವರೆಗೂ ಅಪ್ಲೋಡ್ ಆಗಿದ್ದಿಲ್ಲ, ಎಲ್ಲೂ ಸಿಕ್ತಿದ್ದಿಲ್ಲ. ನಿನ್ನೆ ನಾವು ತಗೊಂಡ್ವಿ, ಅದು ಓದಕ್ಕಾಗಿ ಇಷ್ಟು ಬಲ್ಕಿ, ಬಹಳ ಬಲ್ಕಿ ಅದು. Justice N.S. Sanjay Gaudru. It appears to be, my lords, dealt all the issues because it's 130 pages, 150 pages. We will go through and
at the request of learned counsel for the petitioner, release this matter on 4th of December.
Seal number 44, Siddharuda B. Pujari.
Respond number 3, madam. Senior is on VC, madam.
Waiting for the give it out. But I request for tomorrow, Lordship. There is some inconvenience now. Internet
ಮೂರನೇ ಸರಿ ಬರ್ತಾ ಇರೋದು.
ಇಲ್ಲ,
ಏನ್ರಿ?
ನಾಳೆ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇಟ್ಕೊಂಡು
ಹೋಗಿಲ್ವಾ?
ನಮ್ ಕ್ಲೈಂಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ನಾನು ನಿನ್ನೆ
You for the appellant?
I am for the respondent.
DR Sarthi is for respondent.
Number 3, my lord.
ನಿಮ್ಮ senior counsel ಯಾರು?
DR ರವಿಶಂಕರ್.
ಎಲ್ಲಿದ್ದಾರೆ?
ಅದೇ ಪಾಸ್ವರ್ಡ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
ಪಾಸ್ವರ್ಡ್ ಬೇಡ, ನಾಳೆ ಇರ್ಲಿ. ನನ್ಗೊಂದ್ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ. ನಾಳೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್.
ನಾಳೆ ಆಗಲ್ರಿ.
ಮಂಡೇ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ.
At the request of learned counsel for respondent number 3, release this matter on 3rd of December.
Publish.
Clearing matter. Seal number 45, Shivkumar Kallur.
There are 3 appeals, my lord. The other side, I am told they have engaged a senior counsel. ಯಾರು ಗುರುಮಠ ಎಂಗೇಜ್ ಮಾಡಿ. The question would be, my lord, suit for partition and separate.
Many of them, Bapu Goda Siddhappa.
Yes, my lord. In fact, the
Kalaburagi.
One of the application is filed for impleading, my lord. They want to, I'm not sure your matter, saying that she has purchased the party before filing the suit. So she wants to come on the record, my lord, that can be allowed. Because during the lifetime of the my lord father, the property was purchased.
You are the plaintiffs?
My lord, I am the defendant.
Defendant ಅಂತಂದ್ರೆ then we'll have to hear the plaintiffs whether they would want the application to be allowed. Alva?
ಹೌದು. Some
matters called out. There is no representation for the respondents. Full stop. Release this matter on 4th of December.
Second week ತೆಗೆಯಬಹುದು. Second week ತೆಗೆಯಬಹುದು. 4th, 5th ಭಾಳ ಇದೆ.
10th of December.
Thanks. Ninth it.
9th.
Serial number 46, additional SPP. 46.
Mr. Santosh Patil.
Santosh Patil for respondent.
Matter is called out. There is no representation for the respondent. Release this matter on 4th of December.
Serial number 47, RS Siddhapurkar.
Matter is called out. There is no representation for either of the parties. Release this matter on 4th of December.
Serial number 48, Vikram Jay Kumar.
Same order.
Serial number 49, Regimat.
Same order.
Serial number 50, RS Siddhapurkar.
Same order.
Serial number 51, Krupa Sagar Patil.
You Shivanand Patil or
Respondent.
MFA.
For the claimant.
Motor vehicles. Motor vehicles.
Yes, ma'am.
Claimants.
Yes, ma'am. I'm for the claimant. Sudarshan sir over appear.
Sudarshan or?
They have, company has filed one appeal, my lords.
That is Krupa Sagar
Owner has
Patil.
also filed.
That is Sudarshan amma.
My lords, owner as well as company both have filed an appeal.
Owner also has filed.
Yes, ma'am.
So
Owner
Krupa
has-
Sagar Patil ಅವರು owner.
Owner. And
Sudarshan
Sudarshan my lords
ಅವರು
appears.
insurance company.
Yes, ma'am.
ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಕಲಬುರ್ಗಿ ಅದು ಸುದರ್ಶನ್ ನೇಮ್.
Kindly pass over, my lords, I'll inform.
R1. ನೋಡ್ರಿ ಇದು 20945 ಅದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಯಾರು ನೋಡ್ರಿ?
944.
ಏನ್ ಹೆಸರು?
Vishweshwarayya.
ಕ್ಲೈಮೆಂಟ್. You are not aware?
No, no, that is not being.
ಮೂರನೇದು 200945 is not connected with this?
No, no.
Wrongly connected?
Yes, my lords, that is wrongly connected.
ನೋಡ್ರಿ ಅದು MVC ನಂಬರ್ ನೋಡಿ.
MVC ಬೇರೆ ಇದೆ. MVC 1059 of 2012.
ಇದು wrongly connected ಅಂತಾರೆ.
Yes.
ನೋಡ್ರಿ 2 MVC ಇದೆ ನೋಡ್ರಿ. ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಹೆಸರೇನು?
ಶರಣಯ್ಯ, ರಾಜೇಶ್ವರಿ ಅಂಡ್ ರೂಪಾ, my lords.
ಇನ್ನೊಂದು ಯಾವುದು? ಇಲ್ಲ ಕೆಳಗಡೆ ಡಾಕ್ಟರ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ. ಸೊ ಅವ್ರ ಕೇಸಲ್ಲಿ ಹಾಕಿರೋದು. ಸೊ ದಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 is ಡಾಕ್ಟರ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಅಲ್ಲಿ.
Yes,
ಅದರಲ್ಲಿ
944-059.
A week's time is granted to the learned counsel for the appellant in MFA 200945 of 2018 to take fresh steps for service of notice on respond number 1 claimant. 2 weeks ಅಂತ ಮಾಡಿ.
Request for a date, my lords, because
ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ರಿ? ಈಸ್ ಆಲ್ಸೋ ಎ ಕ್ಲೈಮೆಂಟ್.
yes, ma'am.
ಅವ್ರು ಬರ್ದೇನೆ how to decide the matter. Yes.
Case number 52, Babu H. Metagudda. 52.
Matter is called out. There is no representation for either of the parties. Stop. Release this matter on 4th of December.
Case number 53, Avinashi Uplankar.
Release this matter on 9th of December.
Case number 54, Sangan Baswa B. Patil. Sangan Baswa B. Patil.
Respondent is served.
Served.
Absent.
Next week, my lord. Next week.
ಏನ್ರಿ ಒಂದ್ you have no opposition.
Matter reach out to ನಾನು prepare ಆಗಿಲ್ಲ ಸಂಘ.
At the request of learned counsel for the appellant, release this matter on 4th of December.
Case number 55, Biradar Kalyani.
Request the honorable to recover balance amount of 30,000 rupees. He has given an undertaking. I am going to be wife appellant.
Already, my lord, 55,000 has been paid by the respondent towards arrears of maintenance. Today, he is ready to pay 15,000 more, my lord, out of the outstanding amount.
He is against his own undertaking, my lord. Against his own undertaking. He has admitted to give an undertaking within.
ಹೌದು, ಇನ್ನು 30,000 ಬಾಕಿ ಇತ್ತು. ಇವಾಗ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದೀರಾ?
15,000.
15,000.
ಅದು ಅವ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ವಿರುದ್ಧ ಆಗ್ತದೆ. ಅವ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ರೆ ವಿರುದ್ಧ ಅದು ವಿದಿನ್ 2 months ಅಂತ ಬರ್ದಾಕ್ಯಾರ ಅವ್ರು 26 ಸೆಪ್ಟೆಂಬರ್.
ಹೌದ್ರಿ, ಹಿಂಗಾದ್ರೂ ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ರಿಕವರ್ ಮಾಡಿ ನಿಮ್ಗೆ ಪೂರ್ತಿ ಕೊಡ್ಸ್ಬೋದಲ್ಲ.
ಅವ್ರದ್ದು ಅಂದ್ರೆ ಅವ್ರು he is going against their own undertaking.
Yes. ಕೊಡಿ.
Due to paucity of funds, my lord.
The respondent has today paid a sum of rupees 15,000 to the appellant before this court. Full stop. ಮತ್ತೆ ಬಾಕಿ
It will be adding to another 5,000, my lord. Monthly 5,000 will be added.
This order was passed on 7/11.
If 2 weeks time is granted, my lord.
July ದಾಗ ಇದೆ.
ಇಲ್ಲ,
From
this
the
order.
From the date of petition ಅಂತ sir. From the date of petition ಅಂತ. Order is from the date of petition.
ಹೌದ್ರಿ, in our previous order 7/11/2024 we have recorded, however, a sum of rupees 30,000 is still remaining.
ಈಗ ಈ ತಿಂಗಳು 5,000.
ಒಂದ್ ತಿಂಗಳಾಗಿಲ್ಲ.
ಇದು ಆ ಮುಂದಿನ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಆಗುತ್ತೆ.
ಆಯ್ತು. Next para, release this matter on ಯಾವಾಗ್ರಿ?
ಅವ್ರಿಗೆ ಕೇಳಿ ಕೊಡೋರು ಅವ್ರಲ್ಲ ಕೊಡೋರು.
2 weeks, my lord. 2 weeks time.
On 10th of December. 10th of December to enable the respondent to pay the remaining amount.
Remaining specified amounts ಅಂದ್ರೆ 20,000. ಈಗ 15 ಕೊಟ್ರೆ 5 ಸೇರಿದ್ರೆ 20,000. 20,000. 20,000 ಸರ್, 20,000.
ನಾವೊಂದು ಏನು ಹೇಳೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಮತ್ತೆ ನೀವು ಲೆಕ್ಕ ಹಾಕಿ ಹೇಳ್ಬೇಕಾಗತ್ತೆ.
ಅದೇ.
ಎಸ್.
ಆಯ್ತು.
Passed over matter. Seal number 44-0.
Yes, Mr. Ravi.
In compliance with the direction issued by this honorable court on the last date of hearing, my lord, the director, my lord, has already forwarded, my lord, the recommendation. My lord, since there is one vacancy, my lord, in the psychiatry department, which is vacant, my lord, but the recruitment has to be done by the governing council to that post. Unless the governing councils give me the approval, my lord, I cannot give anything in writing. But I have already communicated, my lord, the decision along with the copy of, my lord, this order.
Okay, please give it.
I'm sorry, my lord, today morning only I have received.
No, afterwards, if file it along with the memo. Learned counsel for response number 1 and 2 has filed a memo along with the communication dated 21/11/2024 made by the director of the respondent institution to
Director of Medical Education, not
the director of medical education. Stop. Learned counsel submits that efforts are being made to ensure
any other vacant post ಇದ್ರೆ ನೋಡಿ.
Huh?
If there is any other vacant posts in the institution also, my lord, could be considered. Order dated, my lord.
for appointment of the appellant.
No.
ಇಲ್ಲ,
No,
appellant
fourth
was
respondent.
already appointed, which was challenged by
Fourth
respondent.
ನಿಮ್ಗೆ
ಹೌದು. ಅದಕ್ಕೆ 11/11/2024 ಗೆ last, my lord, 4 lines, the governing council of respondent number 2 Bidar institution may also consider the appointment of respondent number 4 in any other vacant post in the institution. Sir. We have found that there is one post which is vacant, my lord, which is my lord, could be filled through, my lord, the respondent number 4. But for the post of this professor post, my lord, it is the governing council which is the appointing authority. I being a dean of the institution, I cannot, my lord, issue any order. I have only recommended, my lord, that there is one post vacant which could be considered for respondent number.
ಏನಿಲ್ಲ respondent number 4 is appointed
She is not appointed. It's a appellant.
Appellant.
Appellant was appointed,
That was
which
challenged.
is challenged by respondent.
Respond number 4, my lord.
Respond number. Now whatever appointment has to be given to the respond number 4. Appellant is already appointed, my lord, he is
That's what
serving.
to respond number 4.
Yes.
Huh?
Appellant is already serving, probationer is already declared.
Either as a psychiatrist bracket child, in a vacant post in the institution or any other vacant post.
That is the only vacant post which we have found, my lord, in the institution.
ಒಂದೇ ಅದೇ ಹೇಳ್ತಿರೋದು ನೀವು
ಹೌದು.
ಅಷ್ಟೇ.
Now decision has to be taken by
Psychiatrist
government.
child in a vacant post in the respondent institution. Full stop. However, the decision of appointing a person as professor, psychiatrist, psychology is possible only at the hands of the
Governing council of the
Governing council.
respondent
governing council.
Governing, of which principal secretary is the chairman.
And therefore, the process may take a little more time. Full stop. Next para. Release this matter on 16th of December.
Interim order.
Huh?
Interim order is there.
Interim order granted earlier stands extended in the next date of it. What
Please.
else?
Please. Much obliged.
Please, I'll.
Sena?
ಸಮಾಧಾನ ಎಗ್ರಿ ಬರ್ಲಿಕ್ಕೆ ಇಲ್ಲ ಹಾಕಿ ನೋಡಪ್ಪ ಓದಪ್ಪ ನೀನು ಯಾರು
ಕೋರ್ಟ್ ಆದೇಶ ಮಾಡೋದ ಮತ್ತೇನ್ ಮಾಡ್ತಾರೆ?